आइटम 801 सर अपना कैमरा ऑन कर लीजिए। आइटम 801
Sorry? You are taking public transport, is it? Very well. Eight 801, anyone? दीपक जी ये लगाए काम नहीं कर रहे This not working. And Mr. Kamlesh. 801 is there, but he's not. Mr. Kamlesh?
Yes, Mr.
Yes, your matter had come up on 24th April and you took time. Now you move a little. Mentioning itself
My
name
lordship,
वाले तो
my
cases का
lordship,
क्या
I
होगा?
make, my lordship, I make an application for stay. My
You
lordship,
have, but on the last date when the matter came up, you took time. 24th April, you had taken time. That's why the date was given as 17 July. Now you move a mention memo.
yes, my lordship.
You are a lawyer.
My lordship, kindly, yes, my lordship. My
You
lordship,
at least
kindly
have to
give me
wear the coat and gown. Do not appear without wearing the full dress, please.
my lordship, I am with complete dress, but my lordship, I'm in transit, my lordship. I just going.
विवाद ऐसा है तो क्या होगा?
My lordship, kindly list the matter within a week, my lordship, for the stay application, my lordship.
It's
Not a
not
complete
possible
matter,
to
my
take
lordship.
it up before the break. If there was urgency, you ought not to have asked for time on the last occasion.
Yes, my lordship.
Then let it come up on the listed date, please. Nothing. Item 1. Oh, it's the doomed exercise. Item 1.
Your Lordship, I'm sorry, one matter is listed tomorrow, item number 7. I praying that my IA will also be listed tomorrow, my lord. That is, I am appealing for Municipal Corporation, Faridabad. My one IA is listed tomorrow as item number 7. One IA is listed. My IA may also be listed, my lord. I'm praying for that.
Give your IA number, please.
Yes, I will give the IA number. Yes, IA number is. It is 150529.
Of which year?
2026. And the other one is 27302 of 2024.
Which one is coming up? 27.
No,
304
another
is
IA is coming tomorrow. I am praying that my IA should also be listed along with that IA.
Both of these you want listed.
Yes, along with the other IA which mission.
Got the other IA number also?
That is, I think, 312. That is listed tomorrow.
Very good. Just check which IA is that. Yes.
Oblige,
Item
deeply
1.
oblige. Deeply oblige. Deeply oblige.
Item 1.
Please, Your Lordship, I appear for the
Milord.
state.
Yes.
My lord, this is an anticipatory bail,
Have
my
you
lord.
received the counter
Last time, your lordship has
number
directed
2?
the.
Have you received the
I am
counter-affidavit filed
petitioner.
by respondent number 2?
Yes.
Yes, my lord. Yes, my
You
lord.
have. You don't need to file a rejoinder to it.
My lords, may give time, we will file the rejoinder, my lords.
I have to advise you to do that. Joint counsel for the petitioner.
My lords, in this case, co-accused has already been granted bail by this honorable court, my lords.
Well, the allegations against you seem to be quite serious. Respondent number 2 says funds were diverted to your account also.
Using his ID.
My lords, why would I use my unique ID to do a fraud, my lords? My lords, I am
If you
used as
ask
a
us a question, you need
scapegoat
to
in
give
the
us the
entire
answer.
scam which is happening
We're
in the
not going
bank.
to be able to answer you as to
And
why
my
you're
lords, I am
forensic
already
court
ready to cooperate in the investigation process.
Very well, file your rejoinder. For the petitioner 6 times.
Yes, my lords. I'm grateful.
Counter-affidavit filed by respondent. The matter dated 13/10/2025 shall continue to operate till the next hearing. Who's appearing for the state in this?
I'm appearing for the state, your lordships. In fact,
Did you find any diversion of monies into his account?
your lordships, I don't have instruction regarding that,
Because
sir,
R2
your lordships,
specifically
but your
says
lordships,
that-
his ID was used for depositing of 4 certificates, and he has 2 criminal antecedents, your lordships.
Very well, but also check on this because R2 specifically says that the funds were diverted to P's accounts.
Please, your lordship,
Whereas
I'll
your
check
counter
that.
seems to be silent on that.
Please, your lordship, I'll check in.
Check that.
Please.
Learned counsel for the state shall also is permitted to file an additional affidavit if necessary in the light of the amendments made by respondent number 2 in his counter affidavit. Based on August 6th. Item 2.
Gratefully.
Item 2.
Lordship,
Yes.
made please, your lordship. Well, this is a case.
Yes, counsel.
Well, this is a case. Well, the petitioner has challenged before the High Court the condition of suspension of sentence. Well,
Well, out of 5
138,
cases, you
Malad.
seem to have got 10% in 4 of them. Is that correct?
In 4 cases, my lord.
So maybe
Yes,
in
my
one
lord,
you
I
can pay
have submitted.
20% then. In one you can pay 20%, can't you? If you got 10% in the remaining 4.
Malad, in reality, when it was
How
argued
much
by
would
the
it come to? 10% in each of these?
10%, my lord, in totality, my lord, it's 40 lakh check, my lord.
Total 5 checks together is 40
Yes, my
lakh.
lord. Yes, it's not more than. So this present one, which is before my lord, is 5 lakh.
Is 5
So, my
lakh.
lord, in 4 out of 5, 4 have been granted. If my lord may consider, that's why I produce all those
4 lakhs
documents.
is not much then.
My lord,
Total 4 lakhs
10% in all
Give it
their
20%.
5.
20%. So it'll be 1 lakh then.
Only, my lord, if it can be 10%, my lord, all similarity will be follow, my lord. Because
Did you
in
not,
all 5
did you not
cases,
cite the other orders before the learned acting chief justice?
no, my lord, it was decided previously by this impugned order is a previous order.
I think it will interfere in this. In the remaining 4, you've got 10%. In one, you can pay 20%. What is that?
Yeah, my lord, if my lord will kindly consider, my lord can, without issuing notice, can do it, my lord, because this is something which is going on. The other side is aware about it, my
On
lord.
fact,
For
we are
10
not inclined to interfere with the impugned judgment and order passed by the High Court, especially petitions accordingly dismissed. Though there is no consideration by the learned acting chief justice on that ground, we may have interfered. But for the fact that you've got 10% in the remaining 4 cases.
The remainings are, my lord,
Hardly
the lesser check amount, my lord. The remainings are
Maybe
less.
so, but it still compensates, does it not? It's not like you have to pay 20% for all 5 cases.
I quite follow, my lord. I quite follow. Lordship, delay may be controlled.
Delay continue.
Lordship, grateful.
3, no counter. 3, who's appearing for the state, no counter affidavit.
Yeah, I'm appearing.
Oh, I see.
I'm appearing for the state.
CBI. CBI,
I'll file it.
All others have been granted bail, my lord. All others have been out of 10. 9 have
They
been
at least
granted
need
bail.
to have one opportunity to file a counter.
Yes,
Last date notice was issued. First time it's coming up.
Yes, your lordship may give me a short date. My lord.
Yes. Learned counsel
Black.
appearing for learned ASG appearing for the CBI seeks time to file a counter affidavit, usual order, based on 15th July.
15th July is far away, my lord.
You want it during the partial working days, is it?
No, before vacation.
No,
my
no,
lord.
that's not possible. If you're not going to use your, I don't know whether you are also calling it vacation or partial working days. So if you want to work during the partial working days, we'll give you a date during the partial.
Yes. Your lordship may give me it. Give me it. Yes.
List on 18th June. 18th June. Yes.
Please. Item number 4, my lord, I'm appearing for the petitioner.
Yes.
My lord, this is a case for cancellation of anticipatory bail granted to the respondent number 2, my lord.
The fact that you filed a suit against your brother and the
My lord,
father, stepfather,
That is after that, my lord.
seems to indicate that you have perhaps another axe to grind there. It's not.
No, my lord, see, I was 1 year old when I was adopted by the respondent
No,
number
but
2.
the timing of your FIR is perhaps
My lord,
what is with the High Court.
My lord, the timing may not wash away the act of respondent number 2 by what
It's
he
only
has
a
done with
grant
me.
of anticipatory bail. The case will still have to be tried, but
My lord, look at the pressure of this family that they have got this case, the SIT constituted and got the cancellation report, which is still pending. They have not filed it.
he's been out on bail since 29 November 24. We are hardly going to cancel it at this
My lord, I
stage.
see, my lord, thereafter,
If you have a case with regard to him threatening, what
Yes,
happened to your complaint? Is a fresh FIR registered?
my lord, he was called to the police station Mohali, my lord. Thereafter, my lord, they just warned him and that's all, my lord.
Well, if he
My
does
lord,
it,
I have written a complaint that she
get
had
a FIR registered. That could be a ground for cancellation of the bail, but we are not going to interfere with the grant of the bail.
My lord,
Find no good
poor
ground in
girl,
this
my lord,
interfere
she
with
has
the
nobody.
judgment passed by the High Court, the specially petitions accordingly dismissed. If the dismissal of the specially petition shall, however, not preclude the petitioner from seeking cancellation of the bail granted to respondent number 2 if sufficient grounds are made out therefore. That's the only relief we can grant you.
Please.
Yes.
My lord, I appear for
Five.
petition in item number 5. My lord, this is a
All three
petition seeking
items?
day. All 3 items, my lord.
All 3 items.
For petitioner, my lord.
Well, all 3 of you were in the vehicle and it's a commercial quantity.
Yes, my lord. My lord, I'll just like to show, my lord, 2 or 3 documents to your lordships. My lords may have page 21 first, my lord.
Page 20.
This is the informal report registered by the police.
Yes.
My lord, according to prosecution, the date and time of incidents, my lords may kindly note, somewhere in the middle of the page, 24/7/25 at 11 a.m.
Yes.
My lord, this is a police case.
Hmm.
This informal report is registered at 7:15 in the evening. And the FIR is lodged the next day. My lords may have page 39. FIR is at page 39.
What are the distances? Where was this?
1 kilometer, my lord. 1
Just a
kilometer. In the
kilometer
FIR
away.
itself, it is mentioned. My
NH
instructions are
Road,
it is-
30 Road, Tongpal.
Yes, my lord.
This is on the national highway. So obviously
National
it must
highway,
be
my lord.
outside the city.
No, my lord. Page 39 is the FIR. Page 40 is the distance from the police station. 1 kilometer. My instructions are it is less than 1, but it is 1 kilometer in the FIR. All the punch witnesses have turned hostile, my lord. All the punch witnesses have been examined.
Direction is not.
Let us see what they have to say. Issue notice returnable on.
My lord, it is after notice, my lord. Counter has
Oh,
been
it's
filed by
after
the
notice.
state.
Counter is also.
Yes, my lord. Counter has been filed, my
Not
lord.
filed a rejoinder to it though.
My lord, it's not required, my lord, because they have
Not required.
reiterated the entire prosecution case in their counter. The explanation for delay is that there was no internet connection in the police station. Therefore, there is a delay of 24 hours, more than 24 hours in registration of my lord FIR. My lords may have their counter.
Which paragraph deals with the delay part?
Yes, my lord. My lord, I just bring to your lordship's notice. My lord, page number 5.
Yes.
Page 5 of the counter, my lord. Last paragraph, para 8.
Yes.
The Dehati NLC unregistered informal report was prepared at the spot on 24/7/25. So they arrest me at 11 and they are saying they prepared it at spot, but it has been prepared at 7:15 in the evening. Following by the registration of FIR bearing so-and-so at PS Tongpal on so-and-so at so-and-so hours. Online registration on the police portal was completed on 25/7/25 at 11:20 hours owing to network unavailability. My lord, delay of registration of an FIR is a plausible defense which, my lord, is taken in trial. My lord, this is the explanation that prosecution gives, that they did not have an
Do you
internet
have
connection.
any past cases?
No, my lord, no antecedents.
No antecedents. Who appears for the state? State counsel?
My lord, my friend is muted, I suppose. My lord, item 5, Mr. Abhishek.
Yes, Mr.
My
Abhishek.
lords, I'm appealing for the
Yes,
state
yes.
lawsuit.
What do you have to say?
My lords, my small submission is that the contraband which has been seized from the petitioner is
We are on the
very
issue of
much.
the delay. We are on
My
the
lords.
issue of delay on your part in registering the FIR,
My lords,
in arresting them. Morning 11 o'clock it happens and you show the arrest at 8:10, 8:30 in the evening.
my lords,
What is the
If it-
distance? You've not said anything about the police station being at a long distance or anything of that sort. All that you've said is some internet glitch was there.
yes,
therefore-
my lord.
How does that account for not arresting them till 8 in the evening if the incident happened at 11 in the morning? What did you do with them from 11 till 8?
It is there, my lord. Delay in our part.
Three granted. All three then. Common on. All three were arrested on the same day, is it not?
Same day,
Lawsuit.
same date, my lord,
July?
same time
Yes.
together.
Very good. They've granted. The appellants are agreed. Order is also the same date?
My lord,
All
order is
three?
of different dates, my lord.
Different dates.
Order is of different dates, my lord.
The appellants are
11th and
agreed
12th.
by the denial of regular bail by the High Court of Chhattisgarh at Bilaspur. Video orders dated 11/2/2026 and 12/2/2026. In MCRC, I've just mentioned the case numbers. The appellants have been in prison since 24/7/2025. The investigation stands completed and the trial has also commenced. Though the quantity of contraband seized, allegedly seized from the appellants, qualifies as a commercial quantity under the provisions of the Narcotic Drugs and Psychotropic Substances Act. We are of the opinion that their continued incarceration is not warranted on facts. We may also note that none of the appellants have any past criminal antecedents. The appeals are accordingly allowed, setting aside the impugned orders passed by the High Court. The appellant shall be released on bail on such appropriate terms and conditions as may be fixed by the special court.
Deeply obliged, my lord.
Obliged, lords.
Your Lordship, in the present matter, the High Court has erroneously passed the order directing the petitioners to surrender in an We request to expand so that it does not set up this evening.
This order, the later orders which followed,
Yes, Your Lordship.
those orders you have not challenged them.
Your Lordship, we had actually challenged them, but there was.
Formally challenged that order.
Your Lordship, we did challenge.
in this SLP.
We did challenge, but the registry said that we cannot challenge it, and there was a defect. They asked me to file a separate SLP.
Done that at least. Because how
Your
is this
Lordship,
going
that
to
is
help
the
you?
process.
That's in the process.
Yes,
is it?
Your Lordship.
So you follow up on that, because just setting aside this order is
Yeah.
not going to help you, because
Your Lordship, I'm
this order has been acted upon and the learned
very well, Your Lordship. What we are requesting is
JM
to expunge the remark and
ASJ
to
has
not act as a precedent.
to notice on this. In the meanwhile, you see that the other SLP is followed up and listed before us.
Fair enough. Much obliged, Your Lordship.
Delay no.
Your Lordship may direct to that effect.
We are issuing notice. We won't say anything further.
But
You'll have to
this comes up again, you better
pursue that
file
other one.
Adjournments.
Yes, Your Lordship, it's in the process. Much
Delay not issue notice, returnable on 15th July.
Lordships, in item 7,
Yes.
may I hand over, my lords, the rule, my lords, with regard to removal of the Pradhan and all those matters.
The metros must be very crowded then.
Metros are very crowded, my lords.
Very crowded.
Difficulty is that sometimes on this online mode, my lords, there's some glitches occur. Sometimes there's a breakdown.
Definitely very difficult.
So it's comfortable to us, my lords. We are having no difficulty.
Very good. As long as you manage to get here, we don't mind it if you appear in person. Yes.
Well, we are just referring on this rule, Uttar Pradesh Panchayati Raj removal of Pradhan's rules. Your Lordships may kindly have. Your Lordships may kindly have rule 3.
Anticipatory bill out.
How is this relevant? He's been removed, is it?
FIR has been got registered without complying.
One of you argue, please.
The procedure for registering an FIR, according to these rules, which governs the Pradhans and Upradhans and all those matters, your Lordships may kindly have rule 3.
3.
Rule
Yes.
3, sub-rule 2.
Yes.
Rule 3, sub-rule 2.
Hmm.
Every complaint referred to in sub-rule 1 shall be accompanied by the complainant's own affidavit in support thereof.
No, but this is a complaint for removal of the Pradhan, perhaps, not a criminal case.
No, it is not removal. It is not removal. They say that there is a bungling in the funds of the panchayat, my lords. So,
No, this procedure must be for removal.
yes, my lord.
Can't apply to the.
Your Lordship may kindly see
Proceedings.
fifth. Your Lordship may kindly see the fifth line, fifth para.
Yes.
Sub para 5, my lords.
So offences alleged.
A complaint which does not comply with any of the foregoing provisions of this rule shall not be entertained.
The offences alleged are under the BNS.
BNS, not under this.
My lord, once the complaint is
You
made,
can't import this into that.
no, what I'm praying is, if a complaint is made and it is bona fidely made, then the police will register an FIR and all those things will be done with the procedure for.
No. This is a separate complaint. That's a separate
Every
complaint.
complaint referred to in sub-rule 1. Sub-rule 1 says what? Any person making a
To
complaint.
the state government.
To the state government. That
Or
is
any
not-
officer empowered
This
in
is
this
not
behalf by
this is not the complaint by state
This
government.
procedure will not apply for registration of a criminal
I'll satisfy your Lordships.
complaint.
In this case, the complaint has been given by some villagers. Not the state officer has made a complaint.
It is not to the state government.
After inquiry, only the FIR has been lodged, my lord.
Your Lordships may
This
then,
cannot be-
State government.
Your Lordships may, my lords, then see my lords may kindly have page. Your Lordships, I'm praying. Your Lordships may kindly have page 44 of my bail application in the Sessions Court, and this I have.
You have 2 past cases also.
Yes, my
You
lord.
have 2 past
That
cases.
even then also they have not disclosed it in the SLP.
No,
my
they are
lord.
not disclosed.
Yes, my lord.
Hmm.
In the
Which
whole
SLP
SLP,
are
it is
they
not disclosed, my lord.
That you have 2 past cases.
Yes, my lord. Although there is a special mention in the High Court or Honorable High
The
Court.
order itself, it's mentioned.
Yes, my lord.
My lords, I'm just trying to convince this honorable court. Your Lordships may
No,
kindly
my
have.
lord, the SLP
My lord,
has
he is not
divulged this.
cooperating, not even giving the documents, my lord.
Just answer the question. please.
I'll answer.
In the SLP, did you mention it?
I'll mention everything, my lords.
Where?
No, my lord.
Kindly
Show it to us.
Your Lordship may kindly see page 44, my lords.
44.
Page 44.
No, in the SLP, you can't say that I mentioned it in one of the additional documents filed there.
This is my complaint.
Show us that from your SLP, where
Please,
you
my-
have mentioned.
Your Lordship, my lords, kindly bear with me for one.
We are trying to bear with you. Please show us from the SLP.
I'm trying to show, my lord. Kindly bear for me for 1 minute, my lords. Page 44, your lordship. In between, my lords. My lords, I belong to the Samajwadi Party, the ruling party, MLA. My
Not
lord,
on the merits of the matter.
the reasons are, my lord, day after day
We
after
have
day.
asked you
day
one
after day after day, my lord,
specific
FIRs are
question.
lodged against me.
Have you disclosed in your special leave petition that you have 2 past cases? If you have, show it to us, please. Where have you said so? The order records it. Did you mention it in your SLP?
My lords, I am on bail on those cases, my lord. Those cases have nothing.
Counsel, we are asking you a specific question. Did you disclose it? Did you not? Yes or no? Obviously, it's a no. If you're not, then Munish Kumar, we find that though the impugned order specifically records the fact that the petitioner has 2 past criminal antecedents, no mention of the same has been made in the special leave petition. In the light of the law laid down by this court in Munish,
My lord, those cases are of 2005.
such non-disclosure is
Still no
fatal to
charges
the
had been
case
filed.
of the
2005
petitioner.
cases.
The special leave petition is accordingly dismissed on this short ground.
Unless I am praying, your lordship, my lords.
Please look up Munish Kumar if you've not looked it up.
My lord, then I withdraw this petition, my lord.
No, no,
Otherwise,
we
these
don't allow withdrawals.
my lord, these observations will come against me, my lord.
This is on that short ground.
My lord,
So there's nothing more.
the reason is, my lord,
Counsel,
2005.
your matter is over, please.
My lord, then I am praying, my lord.
No,
Kindly
no,
allow
we
me
don't allow withdrawals. You've appeared before us often enough to know that.
My lord,
Yes. Next matter. Item 8.
Obliged, my lord.
Appearing in item number 8, my lords.
Yes.
My lords, in this case, charge sheet has already been filed and the accused is in custody since July 24, my lords. There are around, my lords, 16
Kgs
witnesses.
of ganja.
Yes, my lords.
And
50
you are
kgs of
saying
ganja.
that the trial has commenced, but no witnesses are examined. Charge sheet is filed.
Yes, my lords.
Charge sheet
As
was
such,
filed long ago, according to you. 20th September 24.
yes, my lords.
Until now, the trial has not commenced.
My lords, as per my instructions, the trial has not commenced yet. And there are around 15 witnesses in this
Told
case,
you
my
to
lords.
that, because we'll issue notice only on that ground to find out why the trial has not commenced.
My lords, and kindly give me a short
Are you
passover.
standing by that?
I will confirm this.
No. If you're not standing by it, then
My lords, may kindly give me a short passover. I'll just confirm this from my client and get back to you. My lords, has the matter been passed over?
pass over.
Oblige, your lordship.
May it please, my lords.
Yes.
My lord, this is for bail, my lords. So I am inside for 1 year, 3 months, my lord. Charge sheet has been filed on 7th of April 25. There are a total of 14 witnesses.
You file a suit for cancellation?
Yes, my lords. I filed a suit earlier, my lords, and then it's a counterblast. They filed an FIR, my
But
lords.
why did you file it to cancel the document?
My lords, because actually because of the transaction, my lords, they were saying with a very less amount, my lords.
Very well. We'll
So I
issue
filed a
notice to
suit. In
transact.
fact, the FIR is also belated. The allegation is
We are issuing notice, Mr. Kaushik.
I am so grateful. My lords, liberty to serve the standing counsel, my lords.
The counsel is there.
Very well, my lords. If he's there, yes.
Condone. Issue notice returnable on so Mr. Ankit Goel and counsel. Accept
So grateful, my
the
lords.
state. Service shall be effected upon respond number 2 by all modes, including Basti, list on 14 July.
My lords may have it in partial working days also. It's a bail matter. It will appear, my lords. It's a
I'm not working, so it's not fair on my part to visit.
very well, my lords. Very well, my
My
lords.
brother judges, perhaps.
Very well, my lords.
I don't know. Date in the partial working days.
Grateful, my lords. Grateful.
But I don't have the. June 15th. 15th is also Monday.
Grateful, my lords.
I said 18th, I think, no?
My lords, the listing is on 18th of June, my lords. My
Sorry?
lords, the listing on
You want it on 15th or 18th, Mr. Ankit?
I listed on 15th.
Lord.
Yes,
15th.
Lord, if it could be 19th or 20th June. Lord.
No, I am not. Just before
Oh.
15th, my lord. Just
All
before
right.
15th.
19th
All
is a
right.
Friday.
In any case,
19th is a
it's
Friday.
through VC, my lord, we'll do it.
No, when
19th.
I'm not 19th, my lords, may have it on 15th, my lords.
15th is okay, my lord. In any case, it's through VC, I'll appear.
Yes,
Well,
15th, my lords.
It's anyhow only VC, is it not?
Yes,
Partial
yes,
work.
my lord. Yes, it's all
Grateful, my
VC.
lords.
Yes.
10.
May it please, my lord.
We've already
And-
dismissed Pawan Batoria's matter. You are identically situated.
Annexure P8, page 128. The manner in
CIP
which
is you are identical to Pawan Bhadoria. In fact, both of you together joined and filed the petition before the High Court. We've confirmed that very same order in relation to Pawan Bhadoria, so you will have to follow suit. Nothing more to be said. Delay condoned. However, we find no good ground and reason to interfere with the impugned judgment passed by the High Court, especially petitions accordingly dismissed. We're going much slower.
after some time, my lord may grant, if trial does not progress, after 6 months, my lord may say 3 witnesses have already
Very
been
well, at
examined.
this stage, you see. At this stage.
Obliged.
11.
Yes, my lords. My lords, it is now more than 1 year since the High Court had
But
granted
you
me.
have 6 past cases and
Yes,
you are
Milords.
in the habit of stopping people on these rural roads and extorting money from them.
My lords, I was arrested on the
With 6
statement.
past cases, what do you expect us to do?
My lords, in this case, I am on bail in all those cases, my lords. And in this
Well,
case,
obviously,
I
you're
was,
not learning a lesson from the fact that
my lords, I am willing to learn my lesson, my lords.
no, where's the question?
My lords, in this case, my lords, one submission, my lords, in this case, I was
You
arrested.
want us to treat this as your 7th deadly sin and let you off after this, is it?
My lords, this would be
Not
my last
happening.
case, my lord, in that sense. My lords, I was arrested on the statement of one of the co-accused, my lord. There is no recovery from me, my lords. My lords, there
No,
is
not at this stage. Considering the past antecedents, don't say that otherwise. We find no good ground and reason.
my
to
lords,
interfere with the
I am in
impugned
jail
judgment
for
passed
more
by
than
the
1
High Court.
year and 5 months, my lords. I am
At
in
this
jail.
stage, at this stage, we've said. So you spend a little more time, a little more introspection. Especially petition is accordingly dismissed.
My lords, may I renew this bail after 6 months, my lords?
We said at this stage, so we are leaving that door open.
Highly obliged, my lords.
May it please the lords. My lords, item 12. My lords, charge sheet filed, my lords, maximum is 7 years, 119 witnesses cited, my lords, charge and charges also not been framed. And
very well. Issue notice, returnable loan. This can wait till after you've been inside since December. Not even
Since
December,
December.
January practically.
Yes,
31st
my lord.
December, you
31st.
went in on New
But
Year's
my
Eve.
lords, but my lord,
We'll
the
give you a date in
directors,
July.
people
Mr.
with the
Abhishek will give
direct
you a date
link,
in July.
my lords, immediately on the reopening, if my
Yes.
lords will.
15 July.
I am accepting
Grateful,
notice,
my
my lords, on behalf
Great-
of the state.
Someone's taking
Grateful, my
notice?
lords.
I am accepting
Mr.
notice, my lords,
Yes,
on behalf.
Mr. Padmesh Mishra.
Grateful, my lords.
Obliged, my lords.
Yes.
But with your lordship's permission, may I? The intermediate quantity was 20 grams. 20
Little louder.
Yes, Lord.
Little louder.
No, it was 20 grams of intermediate quantity, Lord. Not from me, from the house, Lord. And I'm only the daughter. I'm only the daughter.
He was inside a locked room.
Locked me inside the room.
No. From the inside, you had locked it.
Outside also it was locked.
And you and your mother made a hue and cry about the search being carried out. Obstructed them.
He's been granted.
These other provisions, 221 and 132 BNS are also there.
Not against me, Lord. That's not against me.
Heroin. But still.
All other accused have been granted bail, Lord. All others. I placed.
Seem to be drug dealers is the
Not
conclusion
because
drawn.
I'm only 24 years of age, Lord. Now I've done 25. And 1 year I've been in jail, my lord. I'm grateful, my lord.
Notice,
I'm grateful.
notice returnable on same date in
Yes, July, my lord.
July 15th.
End of July, my lord, your lordship.
So you want end of July?
By such time, I'll have completed some laws and also.
Very good. 30th July.
I'm grateful, my
So
lord.
we
Deeply
shall be
obliged.
affected by all. Anyone taking notice? Item 12? Not 12, 13. 13. Go on. Issue notice.
Item 14, my lords, I'm appealing on behalf of the petitioner, my lords. This is a petition for regular bail. There was a theft in informant's house. Subsequently, during course of investigation, one co-accused was arrested.
Notice returnable on. We'll give you the same date in July. Then 15th.
My lords, if it can be in the partial working days. Subject to
Want it in
lordship.
the partial working days. 22nd June. 22nd June?
Grateful.
Well, so we shall be affected by all means.
May it please your lordship. My lord, this I'm seeking regular bail, my lord. I was only 18
On
years.
your shoes, they find
Yes, my lord. I'll, my lord, address all
DNA
those,
of the
all those
victim.
points, my lord, I'll address. And my lord, I was only 18 years, 3 months. My lord, there were a lot of people. Crowd, I'm grateful. Yes, my lord. Crowd.
There was a crowd there.
Yes, my lord.
Murder committed in the crowd.
Crowd, my lord.
Could fall on anybody.
Yes, my lord.
But some blood-stained clothes were also seized from
Close my shoe, they say that
on
they
the
found a
shoe.
spot.
They
They
said
found the-
DNA, but blood-stained clothes also seized.
There was a spot of blood on the
No,
shoe.
not on the shoe. The clothes also there was some blood.
Because that it says it's a mixed DNA profile, my lord, not.
Okay, but then where did the blood come from?
No,
Only the
we were
murdered
there.
person. Only the murdered person.
No, no, we were there, my lord. There were a lot of.
Very good. Issue notice.
My bad.
They condone. Issue notice. This can wait till July.
Yes, my lord. I was.
15 July.
I'm grateful.
There's some cultural program.
Yes, my lord. There was a cultural program going on, my lord, and I'm grateful.
Item 16, I am appearing on behalf of.
Lord, I am in item 16.
Yes.
The petitioner is in custody for about, my lord, more than eight months now. Was arrested on 5th September 2025. Until that, there is a disclosure statement, FIR delay, my lord, 1.5 years. The first call was made, my lord, on 7/2/2024. I was not the beneficiary, my lord, at any point of time. My account number is not there. My mobile number is not there, my lord.
No, but your call center, you are an employee of a call center.
Earlier, my lord, 30 employees were arrested, my lord. I was
amongst
them. My lord, person who used to work at the instance of, my lord.
Chat and all this. Maybe not what they have against.
Lordship,
Issue notice returnable on.
on KBA to lordship.
Lord, can it
You're
be
for?
my lord, may I request in June, my
I'm for
lord?
the informant, your lordship.
You're for the complainant,
I'm for the
not made a party here. Were you heard by the High Court?
Yes, your lordship. I was there, your lordship.
What do you have
I
to
just-
say?
I just want to point out one thing. Police has recovered 17 lakh rupees in this matter, your lordship.
Not from him though. Some bank accounts were frozen.
Some bank account was frozen.
Not his account. But they know where the money went, so those accounts have been frozen. 17 lakh is there.
But that particular amount was recovered in relation to this investigation.
Very well, but what is there to implicate him, except for that what's his name, that that KK Kalyanshu Kumar Bharadwaj names this man, and then they say there's some WhatsApp chat or something like that.
Correct, my lord, correct.
He did not file that particular statement of his disclosure statement.
Who's Bharadwaj's?
This particular person.
What is his disclosure?
His disclosure statement is that he explained the modus operandi of the.
No, recoveries. Any recoveries made?
Not recovery.
Then without that, confession by itself is of no use at all. So what is there against him though? Nothing else.
Will file.
Source. Why do you fall into all such mobile calls? Mainly gullibility of people.
You actually had a insurance policy which was maturing.
The problem in these matters, Lordship, is that
See,
it's very difficult
everybody
to
wants-
lab all these
Everybody
people.
wants easy money. Somebody calls you and says that you are getting 1 crore, give me 10 lakhs, immediately you.
I vote on the Lordship, but in this case, the facts is different. There's a policy.
Anyhow, we'll include, what is the name? Give the name of the complainant, please. We're informed that the complainant was heard by the High Court, but was not made a party to the proceedings. However, as the complainant has filed a caveat before this court, we are of the opinion that he would be entitled to be heard. He's accordingly implemented suo motu as respondent number 2. Issue notice returnable on.
Not I am for the state.
No,
No, I am already.
someone is there for the state.
Not I am for the state.
Issue notice returnable on 15 July. Service of notice is waived insofar as the respondent is concerned as Mr. So-and-so and Mr. So-and-so. Mr. Ankit Goel for the state and Mr.
Shashank Singh.
Give your name and the name of the complainant, give the full details. Before you leave though, write it on a piece of paper and give, otherwise the whole exercise is doomed. 15 July.
Please.
Oblige, my lord.
Yes.
My lord, in this case,
17.
praying for granting the regular bail to the petitioner in a case of 302. But in this case, petitioner is a lady. And my lord, in this case, what happened? That the incident that was on 19th of January 2024. my lord.
Post-mortem examination report that you filed is obviously not complete. Page 19.
Please, my lord, page number 19. My lord.
It doesn't say
My lord,
anything about the body, what exactly was found. Nothing is
my lord,
mentioned here.
it's
The allegation
mentioned
is
cause of death.
that the father-in-law sexually assaulted her before she died.
Exactly, my lord. As
Is
per
there
the
any
allegation.
evidence of it? The body would have
My lord, it's
disclosed the
only,
the body
my
would
lord,
have
only one line, page number 19. The cause of death in this case is asphyxia
No, but
as a result of smoothing, my lord.
only the cause of death is mentioned without mentioning the result of the
My lord,
total
sexually
examination.
result, there is nothing at all in
How
the
is that
post-mortem
possible?
report.
What
My lord. My lord, my respectful submission that such lady, she's having no antecedent at all, and the custody is around 2 years, 4 months, my lord.
You are supposed
lords,
to
I'm
have
appealing
held
for the
her
state.
hands while your husband sexually assaulted her.
My lords, I'm
Please,
appealing for the
And
state.
then the husband smothers her with a pillow.
Please, my lord. My lord,
Then
as
there's
per the
question.
allegation, they are saying, and the allegation qua the present petitioner that she caught her legs basically at that moment.
I don't think.
No eyewitnesses, nothing at all. It's only the case of circumstantial evidence, my lord.
It's good.
My
No
lords,
eyewitness
There's
at
a
all. my
question
lord.
of you saying that I have ill health, I have breast cancer. That's hardly
Please,
a
my lord.
reason to let you
My
out.
lord, initially, the Honorable High Court, Annexure P5, my lord, granted interim for 8
Interim
weeks.
bail for 8 weeks you were granted. So
Granted, my lord. Subsequently, I am surrendered within the time back, my lord. I am saying
you
that
may have
she is a
surrendered,
lady.
but hardly a case for grant of bail. The young girl
My lord,
lost her life.
my lord, at this stage, my lord, total 20, my
Husband
lord,
is in the
witnesses.
US and she comes for a wedding and the mother-in-law and father-in-law do this.
My lord, as per the allegation, but there's a delay of, my lord, 8 days for gestation of FIR, my lord. The date of incident that was on 19th, my lord.
Delay could
And
not,
my lord,
however, we find out
27th, there is a
found in
delay of
recent
8
interview
weeks,
with
my
the
lord.
impugned
8 days,
judgment
my lord.
passed by the High Court, especially petitions accordingly
verify for the ST, my lord.
passed by the High Court at this stage.
When did you file it?
I'm for the state, my
I
lords.
filed it 29, my lord.
Sorry? I didn't hear. Who spoke up now? 17 R1, you want your name to be recorded? Mention his name, Karan Sharma. It's already there. You get it on advance notice also.
Obliged, my lord. Grateful, my lord.
18. 18.
For the notice.
Your Lordships, I'm seeking a pass over, Your Lordships, item 18.
Suppose respondent.
19.
19, there
Adjournment
is
is sought by the learned counsel for the petitioner on
may Lord have it on the opening of the board.
medical grounds. The matter is accordingly adjourned. There's a delay of 52 days in the filing, 170 days in refiling. And now you want a quick date to be fixed after seeking an adjournment.
Not a quick date, my lord, just after vacation, whatever dates you lord.
Yes,
As soon as approved.
14th August.
And deeply obliged.
My lords, in item 20, I had circulated a letter, my lords, for adjournment.
20 no letter has been circulated.
My lords, today only I got an email that the letter has been rejected. I had mentioned personal difficulty of the council yesterday.
Adjournment is sought by the learned counsel for someone is
My lord, I'm
You are on
the payment
caveat.
for R2, R3, R4.
Very
List
well.
after summer vacation, my lord.
learned counsel wants time, so we'll adjourn it.
Okay, my lord. Our list after vacation, my lord.
Right, yes, it will be after vacation only.
Okay, my lord.
Learned counsel for the petitioners seeks seeks an adjournment on personal grounds. The matter is accordingly adjourned. List on 27 July.
I'm so
Grateful, my lord.
31,
May I
sorry,
please?
21.
May I please?
Was present in court. The order records it.
Yes, my lord.
There is a question of his blaming the council now.
My lord, earlier also.
The
a school
learned judge has
convocation was
taken
filed.
the learned judges have taken the trouble to note that Mr. Narayan Das Germal Masan, appellant, is present in court.
No, my lord, he was not present in the court, my lord.
It is there, page 2. What are you saying? Page 2, top. Advocate Shivaji Yadav for the appellant, Mr. Narayan Das German Masan German.
My lord, that is the grievance. I was not present.
So there's no question of his now saying that I didn't know what was happening. He was present
He's
in
82
court. His advocate asked for permission to
He's
withdraw.
82-year-old person, a truthful person, my lord. He say he was not.
You are given liberty to challenge that order. Whatever your advocate was advising you, you follow up on that. Delay condoned, however, we find no good ground and reason to interfere with the
Delay condoned, my lord.
judgment and order dated 17/3/2025 passed by the High Court. The special petitions accordingly dismissed.
Grateful.
22.
May I please, my lords? My lords, this is an order, my lords, where, my lords, the section 34 order was quite balanced, my lords, and no interference was called for in 37 for mainly for two reasons, my lords. While they claim 29 lakhs, my lords, then 59 lakhs is given to them. The other point is, my lords, that the arbitrator observes that the termination was not given by the competent person. The arbitrator completely missed the letter dated 1/6/2012, my lords, which is annexure P23, which was issued by the superintending engineer, my lords. So these were the glaring things, my lords, in this which warranted an interference under 34. However, my lords, while
On which ground under 34?
my lords, the ground under 34, my lords, may I read the portion at page 877, my lords, of the section 34 order?
Court mention as to why it is interfering under which ground?
Yes, my lords. Yeah, I'm so obliged, my lords. It is at page 877. It's in volume 2, annexure P48, my lords.
877.
877.
Yes, 877.
Yes, my lords. My lords has it, then I'll read.
870.
The 2 volumes, my lords. It's in
Yes.
volume 2.
Yes.
So, my lords may kindly see from the second para. On perusal of the said letter dated 1/6/2012, it appears to this court that it is none but the superintending engineer PWD who invoked the clause 2 of the agreement asking the respondent firm to pay compensation to the tune of 42,33,000 as per recommendation of the executive engineer. This court thus holds that the principle of law as enunciated in the case of Sassyong Engineering can be squarely applied in this case, since the arbitrator, while allowing the claim number 3 of the respondent firm, committed a patent illegality by ignoring the letter number so-and-so dated 1/6/2012 as written by the superintending engineer PWD, and thus the decision of the arbitrator in this regard can be held to be perverse and liable to be set aside basically on the ground of patent illegality. So this court holds that the award as passed by the arbitrator while allowing claim number 3 of the respondent firm on account of loss of profit is liable to be set aside under section 34 subclause 2A of the same act. And the next paragraph, admittedly, while allowing claim number 3 of the respondent firm on account of loss in profit, arbitrator awarded a sum of rupees 59,51,032, though before the learned arbitrator, the respondent firm herein has claimed 29,76,504. So, Manoj, these are the main two grounds. This 1/6 letter was completely lost
This is
sight.
nothing other than a merits-based evaluation.
My lords, but then therefore,
Then
my
where is
lords,
the question?
my lords, but in 37, where was the question of interference? That's my humble submission, my lords. In 37, when the 34
Merit-based
order,
evaluation that the 34 court undertook. 588.
sorry, my lords, I didn't get that question.
Once that is there, the 37 court is perfectly justified claim.
My lords, in fact, my lords, in my humble submission, my lords, that the 37 court has completely reappreciated the evidence, has dealt with it in a manner as if the 37 court was the arbitrator, and my lords, order has been passed. Whereas, in my humble submission, the 37 court is to look into any error in the 34 judgment, because my lords, Gayatri
You are not
Balaswamy
correct there. Gayatri Balasamy, we have held that the 37 court's power is coterminous with the 34 court's power.
But my lords have
Therefore, it's
also
not
held that
just-
if
it's not
34
just
is
that,
narrow, it
the
is narrow.
37 court is only looking at the correctness of the 34 order.
My
It
lords, so therefore,
exercises all the powers that the 34 court has.
my lords, I am so grateful and obliged, my lords. So
Can't say that the
therefore,
scope of 37 is limited when compared to 34 court's power.
my
That
lords,
is not correct.
my lords, I bow down, my lords, but kindly see the 34 court clearly goes into this fact.
No,
that
this what you have shown us is clearly a merits-based evaluation.
therefore, my lords, court the 37 court
more.
reappreciate the merits. That's my humble submission, my
No,
lords.
no,
This
it
was
has not. It has restored the award, saying that the 34 court ought not to have done this.
my lords, but this perversity, my lords, somebody claiming 29 lakhs, my lords, and then 59 lakhs is being given.
How is it a perverse order?
Shook
How do you say that?
Miss, much more than that. Where's the question? Delay condoned, however, we find no good ground and reason to interfere with the impugned judgment passed by the High Court, especially petitions accordingly dismissed.
Public.
Your Lordship Slimala, I am physically appearing.
How did you manage to come, Mr. Reddy?
There was no prohibition. I was waiting for this thing only, but after seeing that advocates are there inside, I entered.
No, but how did you manage to come? I'm told that most of them have come by public transport. I think the advocates have been, senior advocates have been requested not to bring their cars. Oh, you came by car? You're in breach of the...
I came directly from Hyderabad.
Hyderabad, you came directly. So you're not aware of this. You're not aware of this new circular that was floated. I think they've consulted the Supreme Court Bar Association also about it.
Probably after seeing the video,
Be hopeful that your car still remains, that they don't chase it away.
It is outside only.
It's outside only, very well. So you might be still safe.
Your Lordship.
Yes.
The petition family was enjoying this land for the 3 generations. The earliest gift deed was of 1345, that is 1935. And the corporation itself recorded this number. Permission was occurred in 2022. First show cause notice in 23. On the one hand, they paid compensation for on the one hand, compensation was paid for road winding, my lord, and now they say they road after 2 years after
The second appeal, it is the first appeal.
AMS.
Second appeal, my lords.
Who was the first authority?
Who
was the first authority?
First authority was the court, my lord. The first authority is commissioner.
Second appeal against the municipal.
So an appeal lies under this thing. Appellate remedy was. Miscellaneous second appeal was to the High Court. That is it. Chief Judge Civil Small Causes Court.
Given the liberty to approach the GHMC again. You are given liberty to approach the GHMC again.
Once again. But construction is complete, my lord. Construction, at one point of time, they said, you have did not leave the...
Because in the second appeal, you did not disclose the writ petitions, perhaps.
Yes.
Writ petitions were not disclosed as the finding.
At that time. But I am told that after recently one writ petition was disposed of, leaving it open to me to approach the competent authority by way of appeal. 2 writ petitions are pending.
So you will have to approach the GHMC now because they say it's a public lane that has been encroached.
So, your Lashima can see whether he has been simply the impugned order is at page number 40, not a word is said. He, page 46, may I read, my lord? Page 46. He notes my contention, not a word is said about it. Simply, page 46, my lord.
46?
46.
Yes.
Second paragraph. Accordingly, show cause notice under section so-and-so has been issued to you, white 9 cited, upon which you submitted a reply to the notice wide reference 10 cited, wherein you stated that you are the owner of the premises bearing number so-and-so, AC Guards Hyderabad, dated so-and-so, SRO Golconda. You have also stated originally the property bearing number so-and-so.
No, but the question is whether you are now encroaching onto a public lane, whether you are making unauthorized constructions.
No.
How will we decide those aspects?
Yes. Here, they accorded permission after you may invite your lordship attention to page 40, my lord. It is not
you got the building permission, no doubt.
Yes, my lord.
After that, it's been cancelled now.
Cancelled after construction is over.
After the construction, but according to them, you were also making some unauthorized second floor construction.
There is also misrepresentation in the building permit application.
No.
Is the ground on which it has been cancelled.
First, my lord, they issued a notice, show cause notice, in 23 saying that you did not leave the setbacks. Page 39 is first notice, my lord. First notice, they said you did not leave the setbacks. The explanation is, we said not only setbacks, we left much more. Only thing they were taking exception to a pillar raised at after the first floor. We said it is only for the purpose of garden.
Authorized construction, part of it also still remains?
Yeah, that they issued a notice on page 36.
No, this for the council on the court.
Page 36 is the notice. I submit explanation, the matter ended there. Page 36 is the notice, my lord, alleging that I have not left the setbacks. That was page 36. Explanation was submitted, page 37, and they left the matter at that. After 1 year, on the basis of a letter said to have been addressed by the Tahsildar, he reopened the issue. And we said everything, and without uttering a word, he simply cancelled. And it is not a case where for the first time it is coming. Earlier there was a... Page 37, I submit representation.
A function hall there, and you are alleged to have...
Functional is third respondent. He is the person behind all these things. Functional seems to have been sealed on account of some violations. Now he is after me. Third respondent.
No, but the allegation against you is that you encroached upon a public lane.
First, my lord, in 2023, they issued a notice saying that you did not leave setbacks. That setback part of it, 2011-23, my lord, page 36. With my explanation, they kept quiet. 1 year thereafter, the third respondent person.
Public interest litigation pending.
Pardon me.
What is this public interest?
Public interest litigation is pending is what has
Public
been
interest litigation is saying that
with regard to the encroachment of the pathway.
in the generally that road part of it was being encroached, but a direction was issued directing to the.
No, but the finding on fact is that you have also encroached on the lane.
That was never the case.
It may be a case of the pot calling the kettle black, but both of you are black though.
No. In my case,
You as a party in the, were you a party in the public interest litigation?
No. I am not.
You're not a party to.
No. And here, my lord, in the explanation I said, front part of my property was acquired for road widening and compensation was paid. The question of my encroaching does not arise. In my explanation, they paid compensation to me for widening.
Issue notice, turnable loan.
Once they paid compensation.
24th July. Any threat of demolition now? Threat of demolition is there.
Yes, threat of demolition.
Status quo obtaining as on today shall be maintained with regard to the building in question.
Grateful, my lord. Extremely sorry if I have violated anything.
In fact, well, all of us have our individual opinions, but anyhow, if it helps, it helps. If it doesn't help, this is.
I was maintaining restraint. I was waiting outside. In the video, I saw that advocate friends were there. Now, why not I have the benefit of?
No, there are some. They told us that most of them got here by public transport. Because
much obliged.
My lord, senior is appearing through VC.
Yes.
Please, I appear for the department. It is a claim of the respondents which is logically faulty and that they have not been able to discharge the onus of proof. They claim that they received these gold bars from the 2005
But then the system
of the grandmother.
that appeal was dismissed by the High Court on monetary limit, litigation policy. What
No, that is, under recall, we have
less than 1 crore.
Less than 1 crore.
Your recall is still pending.
The recall is still pending.
That will have to be considered. We can't be considering it.
If we dispose
You need to.
infructuous.
It was dismissed on 18 March 24 till now. If you don't get it recalled,
No,
obviously you have to return the gold then.
About 3 months from the time the order was pronounced.
Sorry?
We filed it within 3 months from the time the order was
They
pronounced.
should have asked for it.
But after that, you've not pursued your recall to get the order recalled.
Yes, pursuing the case before the Honorable High Court. Is that
As matters stand, the finding is that this gold is not smuggled into the country.
And they did not.
Inherited it.
And they
Yes,
did not.
yes, but however, if one looks at it,
Where have you submitted before the High Court that you have filed a recall application? You have not said there is nothing.
The order doesn't record it.
Then they'll have to pursue.
Para number 3, para number 4.
Oh, yes. Learned appear and bear the responsibility.
Has been filed.
Review, not a review.
Doing it consistently before the High Court.
How can a review be maintained? Because
No, but
litigation see, it is the litigation policy of the government. There is no question of a review.
But they cannot be seen into SSC wise because these are consolidated. The value has to be seen in a consolidated way because the SSCs are all related. So we cannot
see, the litigation policy does not say about the consolidated value of gold which is smuggled in all over the country.
You get it from a bank locker. It is not as if it's seized while he's coming into the country or something like that.
These are foreign,
from a bank locker.
No, but these are foreign gold bars which were recovered from the locker, which were not declared.
If he says I inherited it,
My lords, may just see one order of the CSTAT. I'm sorry, I'm appearing for the respondent, my lords. Please see order of CSTAT 165 to 184. This is inherited by my will. There was a will. Please see page 165 to 184.
165. Where is the reference to the bill?
Yes.
Let me have first.
Wait, there's a just 1 second, Uday. There's a reference to the will at page 170, my lords.
Yes.
Yes. May I read it, my lords? It was further submitted that the sell bid was made on so and so, and the recovered gold was owned by grandmother so and so, and left with her by grand. It was admitted that Srimati had that the will in question not given details so and so. The schedule was executed in the year so and so. The officers further sought information from the officer. It was on the officers. Then finally at page 181, after going all three, going everything, they said at page 181. Yes, 4 lines from that bottom. The said will which was executed was duly notarized and stand probated also, my lords. 181, 5 lines from the bottom, my lords.
And what exactly does the will say? Do you have a copy of the will here?
No, my lord, this is, I am appearing on a caveat, my lords, today.
Well, I see. It's not filed.
Let me complete.
So today, my lords, I have 2 submissions. They disposed of. There was an order in 2019 in my favor. Then a High Court order, my lords, in 24. I don't know when they disposed of my gold. And today they are saying.
Lordship, there are 2 aspects which lordships have to consider in this case. First, these gold bars were of those companies.
We are only on whether it is to be returned or not.
Business
At the moment, Mr. Khanna, you have nothing because the finding which has attained finality as on date is that this gold was not smuggled, it was inherited. Once it is inherited gold which you have taken away, you either have to return it. If you don't have it, then you have to return the value of the gold.
Value of the gold, yes.
3.5 kgs.
I would like to respond on 2 aspects here. First, the will is of 2005. The gold bars were of those companies which started the operation post 2006 and 2008. That is the first aspect. The second aspect.
Does the gold bar have any stamp on it?
They have a stamp of the company which started the operation in
Does it bear the year in which the gold bar was manufactured?
No.
There's no such
finding to that effect.
You can't say that the company has come into existence then.
The other thing which I have to point out is that there's a circular which says the refund could not have been made on the market value. It has to be on the basis of the average market price on the day you hand over the goods.
No, you can't take away his gold.
Yes.
You say that I've already sold it.
The law
I'll give you the
doesn't
value as on 2018 now.
Yes.
The law doesn't
17 or
state that
18,
you have to give the market price.
Sorry, we find no good ground and reason to interfere with
So grateful, my lords.
passed by the High Court, especially petitions accordingly dismissed.
So grateful, my lords.
My lords, I am the bona fide auction purchaser in this matter. Auction was conducted by the district revenue authorities. My lords.
You filed a vacate stay follow-up on that, please.
My lords, I'm only request, my lords, is that it may be taken up in a time-bound manner within 6 months.
No, we are not here to arrange the boards of the High Courts, please.
My lords, it's
Go before the
pending.
Chief Justice of that court, if you have a complaint.
My
to
lords,
make.
humble request. It's pending for final
is that?
disposal since last 2 years. In May 2024, it was
You
resolved.
can show him Article 226.
That I may, my lords, but my humble request.
3 subsection and tell him that this is there in the Constitution, but not being followed.
My lords may set any limit, my lords, at least 6 months.
We can't fix a time frame for this. Delay condone, however, we find no grounds to.
My lords may encourage
The
them.
order passed by the High Court. It is for the petitioner to take necessary measures for the listing of his vacate stay petition in the event the main writ petition is not being heard. He is at liberty to make a mention before the Honorable the Chief Justice of the High Court in that regard, especially petitions according. Yes. Your liberty to make a mention Just make a mention and see what comes out.
Grateful, man.
Yes.
Item 26, I am seeking a password in this matter, my lord. I'm being led by Mr. Siddharth, the senior advocate, who's on this.
Password.
Because item 27, the respondent 31 has been added as a party defendant. Within a suit declaration or cancellation of a document, where she was not even a
Liberty
party.
is given to you to disprove her claim that she is the daughter of the first wife.
But that's a separate claim, which she can approach the court, This is a suit for cancellation of document, which she was not even party to.
No, but that property is the property of the deceased husband, is it not? She obviously has an interest in his property. She claims
she's claiming that she's the daughter of the second wife. There's an affidavit filed by the deceased saying that he has just one wife and the children are the petitioners.
We don't know. That's the reason why liberty is given to you to disprove her claim that she is the daughter.
Let her file a separate claim to that effect. In a suit for cancellation of documents, she's coming here.
If that property is his property, then obviously she has a right. We find no good
that could be a parallel proceeding
judgment and order passed by the High Court, especially if petition is accordingly dismissed.
I'm grateful.
Yes.
May I please your lordship? Please your lordship.
Yes.
The impugn order dismisses my application filed under Order 41 Rule 5 of CPC, and the interim stay earlier granted by the Honorable High Court is vacated. Now, the first ground before your lordship is that the Honorable High Court has in effect decided and upholded the fact finding given by the learned trial court without any cogent reasons. My lords, may kindly come to page number 7 of the impugn order. It's para number 14.
Para number 14 is what we're looking at.
Please, your lordship, at page number 7 of the impugn order. Well, it's upon a careful perusal of the material available on record and the impugned judgment dated 17/5/2025, this court finds that a finding of fact.
One moment.
Please. May I continue, your lordship?
Yes. Will issue notice, counsel.
Please, my lords, my delay be condoned, and my lords, yes, tomorrow there is an execution listed against the impugned judgment and decree. My lords, that be stayed. Because in that
earlier interim order was of which date?
My lords, the
23rd
impugned
July
judgment.
2025. Very good.
Please, your lordship.
Delay condoned, issue notice, returnable on.
My lords, may I please submit one thing, my lords?
14.
But its execution proceedings is listed tomorrow before the learned additional district
17th
and
August.
section judge. That be
Shall
stayed, my
be
lords,
effective
because
by all modes, including Dusty. Earlier interim order dated 23/7/2025 passed by the High Court shall stand restored and shall continue to the next hearing. That should do.
I am so grateful. Deeply obliged.
Well, it's in 30, I appear for the petition.
Yes.
Now here we requesting notice for the reason that there's an interesting question of law. It has to deal with, I might just indicate,
coming to us at every stage, but now the main case is decided.
Yes, and that's why there is this issue under Article 243X and 243ZF of the Constitution. Your Lordship takes that up.
Are they extracted here? No.
They are extracted. Well, not ZF, but 243X is, I think it's quite used to have a book. But if you, anyway, I can take your Lordship to the review.
Which page is it,
Please
Mr.
go to page 8.
Page?
One of the sections, 8.
8.
8 as in 7, 8.
Is it? Oh.
Yeah.
Yes.
Now, your Lordships may see 243X towards the foot of that page. In para 8. So where I place it? Power to impose taxes by and funds of the municipalities. The legislature of a state may by law authorize a municipality to levy, collect, and appropriate such taxes, duties, tolls, and fees in accordance with such procedure and subject to such limits. So I am emphasizing the expression subject to such limits. Now, there is another statutory provision, a provision in the Constitution of Article 243ZF, which gave the state governments 1 year to bring their local laws and municipal corporation laws, etc., consistent with the provisions which were introduced by the 74th Amendment. Now, what has happened in our case, your Lordships, will just go, will directly go, and why we raise this challenge. Please go to page 112, 113.
Yes.
Now, at 112, you will find there is a quoted portion in the communication.
Yes.
So the communication to the cooperator, this is what we had, and this is the resolution which came to be passed. Now you'll find a reference to section 479(2) on the 5th line at the foot of page 112. You know about that?
Yes.
479(2). Now this is an old provision of the Bombay Municipal Corporation Act dating back to 1888, although it has been subjected to some small modifications, etc., which are not material for our purposes. I'll take you to that provision for a moment. But please see what was challenged. So I'll just place this. Municipal corporation, by making partial changes in the earlier orders passed by resolution number so and so. So this is resolution 999 dated 11th December 2009. As proposed to making revision in advertisement fee as known in Counter A and Counter B in group Ker and Ker, and in column 5A in group G as showed in the appendix annex here 2 in the first in the fee schedule for advertisement license issued under sections 328 and 328A of the Municipal Corporation Act 1888 by making a hike to the extent of a flat 80%. So first, they hike it 80% the existing license fee. Then please see what happens. Of the prevailing rate for a period of up to 1 year after the sanction of the municipal corporation. And to the extent of 10% per annum every year following thereafter, and by converting the same to the nearest round figure. So they introduce a law which is open-ended, which increases the license fee without any limit, 10% year on year. And as we have explained in our petition, it is compounded. The effect is compounded. So our legal point is that assuming the legislature has, we assume, and it's correct that the legislature has the power to grant, to confer on the municipal corporation the rights to issue, to levy fees, fair enough, but the legislature has to prescribe limits. What are the maximum? What is the minimum? How often can it be done? Now, there is no such provision at all in the parent statute, and you will find that.
479(2) says?
Yes, please have a look. That is also extracted. You'll also find it in page 7.
7.
That's part of the impugned.
Yes.
Your Lordship has 479 towards the foot of page 7. So I'll just place that. Licenses and written permissions to specify conditions, etc., on which they are granted. Now I'll take you to subclause 2. Fees to be chargeable. For every such license or written permission, a fee may be charged at such rate as shall from time to time be fixed by the commissioner with the sanction of the corporation. Our point over here is that this is, of course, an old statute, as I indicated to your lordships. At that time, there may not have been a requirement for limits. So, both under the general law, which is that, look, you can have a delegation of taxing powers, provided there are limits. So, the delegate must know what is the maximum, what is the minimum, etc., which can be prescribed. How often can they revise it, etc. That aspect is completely missing in our respective submission, insofar as Section 479 is concerned, specifically 479. So they didn't bring it to comport with the mandate which is brought in pursuant to the 74th Constitutional Amendment. So that's my first and primary point. This is an issue, according to us, which requires consideration. You can't have an open-ended system. The second is the impact and the effect. Please look at this. 80% increase in 1 year, and thereafter 10% year upon year upon year upon year, without any limit, without any cap. And so we are facing tremendous adverse consequences as a result.
One moment, Mr. Dev.
Untraveled power.
We will issue notice.
I'm grateful. No, I realize that I can't ask for a stay immediately, but I would request notice of stay, because at least the municipal corporation will come forward and say, are they going to keep increasing this 10% year on year? Because at least for the future, there may be some guidance which is to be provided at the interim stage.
Let them come forward, thereafter we'll see.
All right. So then your lordship will just issue notice and take custody.
Issue notice on the special leave petition as well as on the prayer for interim relief.
I'm grateful.
Turnable on 15th, 15th July.
I'm grateful. May I request custody?
Service shall be effected by all modes, including this. Thirty-one.
Lord, please, your lordship, lords.
Yes.
Lord, I'll raise only one point, my lord, which I think, my lord, would appeal to your lordships. Please have a, my lord, this was a contract given to the respondent Newton Engineering on a condition which, according to us, is a mandatory condition, that they would have one technical partner with a technical know-how without whom they cannot discharge their functions. Lord, please come to page 146 first.
146.
146, my lord. Para 117. My lord, your lordship gets, my lord, 146, 117. As regards the role of UEM, my lord, that is, I'm sorry,
the technical partner.
the joint, my lord, constituent of the joint JV. Both sides have made detailed submission, but in our view, it is not necessary to set them out. Admittedly, without the MOU dated so-and-so with UEM, the claimants did not qualify for being considered under the subject tender. Admittedly, the claimant was awarded the subject contract based on the credentials of its technical collaborator, Messrs. UEM India Limited, New Delhi. This is admitted by claimant's witness in answer to question number so-and-so. I'm not reading the answer, my lord. It's an admitted position. Now, please oblige me by coming to page 205.
Show us your agreement itself where you say that is there such a condition in the agreement? Because your agreement is only with Newton.
Yes, my lord. Yes. For that, my lord, if your lordships can come to page 148.
148.
Para 124.
Yes.
But that would be an answer, but I must give it correctly.
Yes.
It must be mentioned at this stage that the...
One moment. 148. Page 148.
148, para 124. My apologies.
Yes.
Because contract does not. My lord, my answer is contract does not stipulate.
Does
My
not-
answer has to be correct to your lordships. But the very fact that I wanted a person with another person with technical expertise, my lord, means that it is mandatory. You cannot do it on your own. Please have a look at 124. Just to answer your lordship's question, it may go against me. It must be mentioned at this stage that the contract does not contain any provision for signature of EUM on all documents, and the contract only makes the claimant responsible for execution. Please now see, however, the respondent insisted on involvement of UEM in the fields whereunder the MOU, UEM had the primary role. MOU between UEM and my lord the Newton.
No, but insisted by way of what? Correspondence?
Yes, my lord, by me. I am the respondent before the tribunal. I am reading, my lord, arbitral tribunal's award.
No, you insisted is what is written here.
Yes.
How did you insist?
By
Did you
way
write
of
to them?
letters, my lord, communication.
By way of letters. you
Yes,
said.
yes, my lord. I'll read further. It may be that respondents were not absolutely correct in insisting that UEM sign all documents, but the fact remains that claimant had to satisfy respondent that UEM was involved and had approved what was submitted. In this context, my lord, please read 205. This is again, my lord, not a fact which is contested or in dispute or held against me. Para 181.
Yes.
Your lordships are, my lord, with me on page 205. My lord Justice Chandran. my lords.
Yes, yes.
Yes.
At the
Yes.
bottom, my lord, page 205, page para 181. It has been very seriously submitted. My lord, I can say it's not disputed by the other side. That claimant failed in its duty to furnish drawings. It was submitted that claimants were to furnish 399 drawings before removal of sludge. It was submitted that claimant supplied only 29 drawings approved or signed by UEM. On the other hand, on behalf of the claimant, it is submitted that all drawings required to be submitted were submitted, but the respondent refused to consider them as most of them were not signed by UEM. But this is where the UEM's role comes. We wanted them to technically take the responsibility of signing the drawings, and out of 399, only 29 are signed by them.
But you do not include this as a condition in your contract itself.
But
It's only by way of
Lord,
later correspondence.
your lordships are right. That's a correct. Correct answer is yes, I did not. But the contract between my lord the EUM and Newton did provide that they would be taking care of the technicalities on the site.
But that was between them. So far as you are concerned, you never made it a condition precedent.
Based upon which we granted the contract. Your lordships may kindly see page 147, para 119.
Both courts have held against
My
you.
lord, I am my lord.
24 as well
That's
as
my
36.
lord. But that may be one of the
There is a
factors. My
question
lord,
of
not-
our going into a merits-based
My
evaluation.
lord,
at
the
this stage.
difficulty is this. Why in my submission, your lordships may consider this.
Contract doesn't even stipulate participation by
Would
you.
your lordships, my lord, allow me to see, my lord?
Even what you read out at page 146,
Yes, my lord.
that answer ends by saying UEM was our subcontractor, not responsible to the ONGC.
My lord, the difficulty is when, my lord, we insist that you will come only if you will be qualified, only if your technical partner is qualified. My lord, I
You have
missed, my
been a
lord.
little more mindful when the contract was drawn up.
My lord, would your lordship see, my lord, 146? 146, my lord, I did not read it, but let me read it. 146, page 146.
Yes.
My lord, the
Only the
question answer. My lord,
signatures
this
were
is
not
it.
there.
Your lordships read, my lord, the first part, but the
Yes.
proposition, your lordships, my lord, I did not take your lordships through. Para 31, your lordships have, my lord, in para 117, it's a quotation.
Yes, we were qualified on the basis of UEM's
Yes, is
technology.
it correct that claimant did not possess?
It's not as if UEM was not involved. According to you, UEM's signatures were not there on all the
No,
documents.
Lord, it was not involved. My lord, that's our case. My lord, illustrate, we have said
That's a purely factual finding. Where is the question?
My lord, one last
Mr.
thing.
Diwan, you are on caveat.
Yes,
My
Your
lord,
Yes, what do
119.
you have to say?
My lord,
Let us see
119.
whether Mr.
Only a minute.
Diwan
my
has
lord.
any more. Let us see whether Mr. Diwan has any more nails for your coffin.
My lord, only one, my lord, better, my lord, lead in the coffin.
One moment.
My lord, I am sure one para will help me, my lord.
Which
Your lordship will
paragraph?
kindly allow me page 147, para 119. This would answer my lord's question also.
Yes.
The lordships have page 147, 119.
No, but
At
this
the
is again
kickoff,
just some meeting that you had.
my lord, kickoff meeting is always, my lord, the first
Very
meeting.
well. Let us see, where did you take the specific stand that UEM was not involved at all? It wasn't just a question of not signing, but not involved at all. Did you take that stand at all?
So UEM was involved in this.
My lord, it was involved, my lord, on a periphery, maybe.
Sorry?
But it may have been involved in a periphery, my lord, as I have pointed out.
That is the whole.
When did you take that contention specifically?
My lord, my lord, it's an.
As far as I remember, there's nothing there.
My lord,
What
can
do
I
you have to
find
say,
out,
Mr.
my lord,
Diwan?
and let your lordships know?
Let us see what Mr. Diwan has to say.
Or, my lord,
Yes,
by
Mr.
Friday, I'll answer this question, my lord. If there is any specific contention or finding.
In there, you would have definitely picked on it, Mr. Obviously, it's not there. Yes, Mr. Diwan.
No, because my points are quite simply that this was that they went in threadbare. It's a unanimous award, apart from the 34 and 37, which were also supported.
Your
It's a
voice is
three-member
not very clear, Mr. Diwan.
Am I audible
Yes.
now?
Yes. Little better. Yes.
Right. So, I'm sorry about that. The point I'm making is that it's a unanimous arbitral award. All three members have concurred. Now, what was the award essentially? Please just consider this. Number one, the arbitral tribunal found that the termination was wrongful. Now, because the termination was wrongful, the bank guarantee which they had invoked was obviously restituted. That was one part of it. The second part of it was that there was some unpaid bill for some work which was actually done. So that was the second limb of the arbitral award. And the third part of it was that there was a loss of profit element, which they also recognized because the termination was wrongful on their part. Now, UEM, just to answer the question, was involved in the project. It had countersigned with regard to several drawings, etc., because there was an ETP which had to be expanded. All these are matters, valors of fact finding, determination by an arbitral tribunal. And now with two courts of two levels of review, I don't believe your lordships under 136 would have much of a role in a case such as this. So I would respectfully submit that the matter deserves to be closed.
Yes.
Well, only last submission, my lord, if it appeals to your lordships. My lord, all public sector undertakings.
134.
My lord, all public, I'm sorry, my lords.
Yes. Continue.
My lord, all public sector undertakings, my lord, always, my lord, this is the model contract, that you will have one person who will be technically qualified, which will make you eligible, and their participation would be all throughout. But I understand, my lord, these broad-based propositions that all three members have agreed and 34 lost, 37 lost. But this is, my lord, the question which needs examination. My lord, when the very foundational...
Not when you don't take the trouble to draw up your contracts, making that clear. That is not there. Once the contract is silent on that, and it's a possible and a plausible view taken by the arbitral tribunal, where is the question of? And that too, it's a three-member arbitral tribunal. Sorry. We find, having heard the learned senior counsel for the parties, we find no grounds made out to interfere with the impugned judgment passed by the High Court, especially petitions accordingly dismissed.
Extremely grateful, my lords.
Your Lordship's item 32
We've dismissed the.
Yes, Your Lordships. However, Your
Sir,
Lordships,
please.
on the last date, Your Lordships had inquired whether we have filed any complaint, police complaint. We have, in fact, filed one. It was in June 2025 itself, prior to
We're
our
not going to take a
issuing any
different view
reply.
now.
And from the very first date, we
We
had
are
been
not
claiming
going
that
to
the
take a
checks
different
had.
view now, counsel, sorry. As
Please, Your
especially petitions filed against the very same order have been dismissed by this court on 7/5/2026. We find no reason to take a different view, especially petitions accordingly dismissed.
Please, Your Lordship.
May it please this court, Millards, I appear for the petitioner on item 33, Millards. Your lordships have, pursuant to Priyanka Srivastava, subsequently in Vijayalakshmi held that the absence of an affidavit under 156.3 is a curable defect. Your lordships have said an opportunity could be granted before passing any formal orders on the 156.3 application. That is point number one. That is held to be fatal against me. Point number two, which is more important, Millards, is that this is not just an application under 156.3, but it is an application under 156.3 read with 200. In a case of a complaint, private complaint under 200, Millards, with all due respect, there was no need for the affidavit to be there, stricto sensu, because pre-summoning evidence could have been taken, I could have been examined. Number two. Number three, Millards, what is essentially also put against me is that this is in entirety a civil dispute, Millards. Can I just impress upon your lordship that this is not merely a civil dispute? There are two dates which are important, Millards. The accused A1, A2 in this case, Millards, are mother's son. The son has a partnership with me. The mother enters into an agreement to sell dated 6/9/2004, pursuant to which there is also a GPA dated 27/1/2005 for consideration, 16 lakhs consideration, page 5460. Acting upon the GPA, Millards, she also says at page 209 that she has received the entirety of the consideration that I have paid to her. On the basis of this, Millards, I go ahead, register this project with RERA. Would your lordships kindly see that registration, Millards, 210. This is extremely crucial. This is extremely crucial. After having done this, Millards, this is a clear case of cheating.
One moment, Mr. Parmar.
Sorry.
Page do you want us to look at?
Millards, 209 is the receipt which she says she has received the entirety of consideration. 210 is the declaration under RERA. Today, Millards, this is a clear case of cheating. I have gone ahead, sold the flats, sold the units to other people based on this GPA, on the basis of this agreement to sell. My civil suit, Millards, the Sessions Court comes to a finding that I have initiated criminal proceedings after I initiated civil proceeding. That's an erroneous finding. Those also I will satisfy your lordship with the dates. But
what happened to your suit now?
Suit is dismissed for default. My Order 9 Rule 9 application. My Order 9 Rule 9 application is pending. But
Still
that's
pending.
That Order 9 Rule 9 application is still pending, Millards. That's at page
2023, your suit was dismissed.
Yes, Millards. It was dismissed on 18th February 23, Millards. I have filed my Order 9 Rule 9 on 10th April 2023. That is pending.
And you're not pursuing that?
Millards, that's pending.
Pending? If you pursue it, it will come up. If you don't take steps to pursue that and you want to hold this Damocles sword over there, criminal proceedings, better way of.
Millards, this criminal proceeding, this criminal proceeding was initiated prior to the civil proceeding. Criminal proceeding is initiated on 24th October 25 by filing a complaint before the Sadar police station, page 99. The suit is filed
24th October 2015, you filed the
criminal complaint. The suit comes only thereafter, Millards. So the
that is also in 2015 only.
That's right, 30th October 2015. But
at that stage, you decided better to pursue both. Thereafter, you made a choice and said, let go of the civil. Criminal is a better way of arm twisting.
Millards, kindly see this, Millards. She takes the entire consideration from me. She enters into a GPA with me. Because I've been non-suited on the question of Priyanka Srivastava and then by a side wind said that this is a
delay could not. However, on facts, we are not inclined to interfere with the including judgment passed by the High Court, especially if it's according to this piece.
Grateful, Millards.
Adjournment is sought by the learned counsel for the petitioner on the ground that settlement talks are in progress. earlier interim order dated 15/1/2025 shall continue to operate till the next hearing.
I'm so glad.
Not petitioner, appellant. Adjournment is sought by the learned counsel for the petitioner to, who's appearing for the respondent in 35 state or private respondent? Respondent number 3. Respondent number 3 is,
My lords, I'm appearing on behalf of respondent number 3.
you've not filed a counter.
My lords, we filed a counter. My lords, it's
Well, you
recorded.
seem to have served a copy on the other side. They've asked for time to file a rejoinder to it. But
My
the
lords.
office report records that you've not filed a counter.
My lords,
Well, you've only shared it with the other side and not with the court then.
no, my lords, it has been filed.
Have you looked at the office report, madam? This is dated 15th May. Paragraph 2 specifically records it is submitted that counsel for respondent number 3 has not filed a counter affidavit so far. Hence, no rejoinder affidavit has been filed.
My lords, maybe it is not on
File it,
record,
please.
my lords. I will just.
Office report dated 15/5/2026 records that respondent number 3 is here to file a counter affidavit. However, it appears that a copy thereof has already been served upon the learned counsel for the petitioner, who filed a letter seeking time to file his rejoinder thereto.
My lords, may kindly not
The
record
matter
that.
is
My lords,
accordingly
it's
adjourned to enable the filing of a rejoinder. Learned counsel for respondent number 3 shall ensure that the counter affidavit is placed on record well before the next date of hearing.
Fine.
List on 19th August. Earlier interim order of status quo dated 25/8/2025 shall continue to operate in the next hearing.
Grateful, Your Lordships.
My lords, for the petitioner in 36, my lords.
Yes.
The petitioner is represented through the successful resolution applicant pursuant to IBC proceedings.
Yes.
In this case, the State Consumer Dispute Redressal Commission ignores the moratorium.
Let us see what the respondent has to say.
My lords.
Who is appearing for the respondent?
Time for this one.
Yes.
But moratorium order was passed on 9/8/2018.
And you filed your
I
complaint before the SCDRC on 4th December 2018.
4 months later. Yes, Lord. I am a-
Therefore, that entire proceeding
Yes,
is
Lord.
hit
Yes,
by
Lord.
the
I am-
moratorium.
My humble submission, Lord. I am a home buyer. They were
Have
supposed
you
to-
at least filed a claim before the IRP or the RP, as the case may be?
No, my lord.
Then where you've dug your
They
own
haven't filed
grave.
their- They haven't filed a written reply before the state commission.
You can't initiate
They were set in
proceedings
court.
after the moratorium order. Where is the question?
But then I go remedialist, my lord.
You dug your own grave there.
But they take money, they don't inform the court also, they don't inform the state commission also.
Either way, your proceedings were hit by the moratorium order. There's no question of trying to save them also. It's completely against the law.
Article 142 of the constitution.
No. Where's the question of our exercise? You are now for the successful resolution applicant. Are you magnanimous enough to give them back their money or something like that?
My lords,
Because in some of the cases, the SRAs have been magnanimous enough to say that even if they did not file their claims, if they have paid more than 80%, will get back their money. How much have you paid?
12/3 has been repaid and 9 more lakhs have to be given.
No, how much have you paid?
12 lakhs.
You won't get an apartment now.
10%.
Apartment or villa, what is it?
Asking for the money.
It's a villa, they paid 10% according to their own admission. And out of 12 lakhs, 3 lakhs is already refunded to them.
Or three has been refunded, is it?
3 has been refunded to them and
12 lakhs you paid out of 90, out of which 3 has already been
because they
refunded.
were unable to complete the sale.
Then you did not stick to the time schedules. Default is there on your part also. Then where is the question?
Your Lordship, may kindly have page 52.
Sorry. Nothing more comes. That's nothing.
Lordship, may kindly have page 52.
Page 52. What does it show? This is the payments you made.
Yes, my lord.
12 lakhs. 5, 10, 15, 1 lakh, 7 lakh, 10. What else? That's all.
Actually, my lord, we were
What were the cutoff dates for the balance
But
payment?
it was because of their deficient service, my lord.
No, but the agreement must have required you to make payment.
Clause 11.
They didn't come forward, my lord.
16, no payment.
No payment after 2016.
But they didn't. Well, loan was sanctioned and then loan was rejected, my lord. They didn't.
Nothing. 2016 to 18, you did nothing then.
No, no, my lord.
January 2016 was your last payment.
Yes, my lord.
December 2018 is your
They
complaint.
didn't come forward to perform their part of the contract.
No, you should have paid amount for the schedule.
Where is the agreement schedule? When were you supposed to make the payments?
In fact, they didn't come. They didn't come forward for registration.
No, you don't want to answer the question, counsel. There's nothing we can do. But if in any event it's hit by the moratorium, there's nothing we can do.
Well, loan was approved twice, my lord, and then it was rejected.
They've granted why are there two appellants?
My lords, they are both connected companies. Both are BCIL.
And which one is the SRA now?
My lords, my instructions are where that both are under the
I see. One is a branch office, one is
a branch of the other.
all right. The appellants, comma, BCIL Z RIA Properties Private Limited, comma, the successful resolution applicant, comma, is agreed by the order dated 5/3/2025, passed by the High Court of Judicature at Madras in WP number 10749 of 2024. By the said order, I see you need to go back to the NCDRC, is it?
And also NCDRCs, because NCDRC, by its order of 31/2024, had rejected on the ground of delay.
So
and
you
that
need
was
to go
affirmed
back
by
to the
the
NCDRC. We will only make this order. Yes. By the said order, the High Court confirmed the order dated 31/2024, passed by the National Consumer Disputes Redressal Commission, New Delhi, in first appeal number 591 of 2023. Refusing to condone the delay on the part of the successful resolution applicant in preferring an appeal against the order dated 11/10/2022, passed by the State Commission, by the Tamil Nadu Consumer Dispute Redressal State. What is that? State
Consumer Dispute Redressal Commission.
SCDRC, State Consumer Disputes Redressal Commission, Tamil Nadu. Full stop. We may note that by order dated 16/10/2025, this court granted stay of further proceedings. 16/10/2020. Stay of further proceedings in EA number 30 of 2023, pending on the file of the Tamil Nadu State Consumer Disputes Redressal Commission, Chennai. Full stop. We may, a few crucial facts would be relevant for the purpose of, for the disposal of this appeal. The corporate insolvency resolution process against the corporate debtor. What is the name of the corporate debtor?
Look, BCIL is the corporate debtor. The successful applicant is issued Dreamlands.
Like this.
Name of the corporate debtor is BCIL.
And the successful
resolution applicant
issued Dreamlands.
stepped into, took over the corporate debtor, BCIL. The name of the successful resolution applicant is?
Aishu Dreamlands.
Where do we find the name?
Well, it's in the order itself, it is there. I'll just point out the page. My lords may give me just a minute. I'll give the name.
There in your synopsis, no?
It must be there in the synopsis too. I had noted the page, but
Corporate data. Corporate entities.
The SLP is filed by the.
In the name of the corporate.
the name of the same company only, because it's now taken over by Aishu Dreamlands. The company still remains, my lords. My lords would find it in page C.
Aishu Dreamlands.
Aishu Dreamlands Private.
Mention it like this. Aishu Dreamlands Private Limited, comma, the successful resolution applicant, which took over BCIL Z RIA Properties Private Limited. Why are you describing it as represented by the managing director? You've been in the SLP. In the High Court also, it's shown as represented by its managing director.
True, my lords.
2022.
My lords, my understanding is that once Aishu Dreamlands became the successful applicant, my understanding is that it has
You become the
yes,
managing director.
we step into the shoes.
We approved NCLT approved your resolution plan in 2019 itself.
2019.
Very good. Then I'll dictate the whole order then. Aishu, comma, the successful resolution applicant that took over the corporate debtor, comma, BCIL Z RIA Properties Private Limited, comma, is agreed by the judgment and final order dated 5/3/2025, passed by the High Court of Judicature at Madras in WP number 10749 of 2024. Full stop. By the said order, the High Court confirmed the order dated 30/1/2024, passed by the National Consumer Disputes Redressal Commission, New Delhi, in first appeal number 591 of 2023, refusing to condone the delay of 105 days in the filing of the said appeal by the successful resolution applicant against the order dated 11/10/2022, passed by the State Consumer Disputes Redressal Commission, Tamil Nadu, in complaint number 16 of 2019. A few crucial facts may be noted for the purpose for the disposal of this appeal. The corporate insolvency resolution process against the corporate debtor at BCIL so-and-so was initiated on 9/8/2018.
My lords, and moratorium was from 9th August 2018.
9/8/2000. That is the date of admission, is it not?
No, that is the date of, yes, the moratorium.
9/8/2018, when an interim resolution professional was appointed. In effect, the moratorium under Section 14 of the Insolvency and Bankruptcy Code 2016 started operating from the said date. In terms of the said statutory provision, it was not open to any litigant to initiate fresh litigation against initiate fresh litigation or continue with pending litigation against the corporate debtor. While that being so, the respondent approached the State Consumer Disputes Redressal Commission, Tamil Nadu, only on 4/12/2018 with his consumer complaint against the corporate debtor in relation to the sale and construction agreement dated 25/1. When was your sale and construction agreement? 25/1/2016. 2016.
25/1/2016.
Unmindful of the statutory scheme of the Insolvency and Bankruptcy Code 2016, the State Consumer Disputes Redressal Commission passed Expiry order dated 11/10/2022, allowing the complaint case filed by the respondent and directed the corporate debtor to refund certain amounts along with interest and costs.
Compensation.
And costs. Upon finding out about the passing of the said order, the successful resolution applicant of the corporate debtor filed an appeal before the National Consumer Disputes Redressal Commission, New Delhi, along with a petition to condone the delay of 105 days on its part in preferring the said appeal. It is this application that came to be dismissed by the National Consumer Disputes Redressal Commission and was thereafter confirmed by the High Court vide the impugned order. Given the aforestated facts, it is clear that the very filing of the consumer complaint against the corporate debtor was hit by the moratorium order, and therefore the successful resolution applicant has an arguable point to be raised before the National Consumer Disputes Redressal Commission. The delay on its part is also not substantial, and given the fact that the order passed by the State Commission was an ex parte one, the National Consumer Disputes Redressal Commission ought to have been more liberal in considering the said condoned delay petition. The appeal is accordingly allowed, condoning, setting aside the orders passed by the High Court as well as the National Consumer Disputes Redressal Commission. The delay of 105 days in the filing of that appeal number so and so is accordingly condoned. The said appeal shall stand restored to the file of the National Consumer Disputes Redressal Commission, and the same shall be dealt with in accordance with on merits and in accordance with law. $37.
Just to be
Page.
and the impugned order.
I'm for the respondent. But we have already
Counter-
filed, counter-filed a video.
You filed a counter only on 15th May.
Lordship.
Anyone for the petitioner?
Petition is still pending. The petition there is an
I'm for the petitioner.
Lord, what happened to your writ petition? Yes, Mr. Upadhyay.
Yes, my lord,
You received a copy of the counter?
I got counter just yesterday, my lord.
You want time?
And I want to file rejoinder, my lord.
Very well. You want counsel for
If lordships permit me.
Yes,
Otherwise,
yes.
I am ready.
No. If you wish to file a rejoinder, we won't deny you. There's an order of status quo in any event. Learned counsel for the petitioner seeks time to file a rejoinder to the counter-affidavit of respondent number 1, which was filed on 15/5/2026. It shall be done within 3 weeks. Earlier interim order of status quo dated 17/10/2025 shall continue to operate in the next year, placed on 13th August.
Highly obliged.
38.
My lords, in 38, I'm appealing for the petitioner. My lords, it appears that the respondents have not filed a counter.
Not filed a counter till now. Who's appearing? Yes, Mr. Satvik. Yes, Mr. Satvik, you'll have to unmute yourself.
Yes, my lords, I'm appearing on behalf of respondent. My lord, the main counsel was in personal difficulty. Therefore, we have moved an adjournment letter.
No,
my lords, the counter is ready. If my lords may grant me 2 weeks time,
Very
my lords, we can file the counter affidavit.
You're appearing for both the respondents?
Yes, my lords.
Very well. Mr. Satvik, Mr. Learned counsel for the respondent seeks some more time to file a counter after usual order.
My lords, there is only one clarification.
Yes.
The advocate on record who has filed the Vakalatnama in item 38 has not filed the Vakalatnama in 38.1, which is a connected matter. So we just want to clarify as to whether Mr. Satvik is appearing in both the
Are you
SLPs or
appearing
not.
in both
Yes,
matters,
in
Mr. Satvik?
both matters.
Very well.
38 and 38.1, both.
Appearing in both cases seeks time to file a counter. Usual order. Earlier interim order dated 5/12/2025. Only in one case or in both?
In both the cases, my
both,
lords.
my lord.
Shall continue to operate in the next hearing. List on 18th August.
18th August. Highly obliged.
39, respondent is not served.
Your Lordship, may kindly grant passover in this matter, Your Lordship.
Respondent is not served, counsel.
As per my instructions, Your Lordship, respondent has been served, Your Lordship. We will be filing our service affidavit of service, Your Lordship.
Then you will have to file it because we'll go by the office report which is dated 15th May and which says that service is not complete and you have not filed an affidavit in proof of dusty service.
We will file. As per my instruction, we will file
Counsel to the petitioner. Take some time to take necessary steps in relation to unserved the unserved sole respondent. Earlier interim order dated 6/1/2026 shall continue to operate till the next hearing. Same date. August.
Obliged, Your Lordships.
My lord has listed it for hearing at the end of the board. If my lord wants, I'll start the matter, my lord.
You will be able to argue online. You are
My lord,
quite clear.
that is,
Who opposes you though?
tomorrow, day after tomorrow, if my lord, I be given physical, because
No, your
some
voice is quite clear, Mr. Tiwari.
quite clear. Then
Your voice is quite clear. If the other side is also equally clear, then we can hear both of you. Then we'll take it up at the end of the list. Mr. Vinayak Sharma, let us see how good your audio is.
Milits, I'm led by.
Milits,
I
believe my voice is clear enough.
Yes, you're also clear enough, Mr. Naidu. So we'll pass it over. We'll take it up at the end of this.
my lord.
Adjournment is sought by the learned counsel for respondents. For the respondents to enable filing of a counter-affidavit usual order. Earlier interim order dated 12/3/2026 shall continue to operate in the next hearing. List on 19th August. 42. 42 services not complete. 41 we have adjourned, madam. 42 services not complete.
My lords, we appear for respondent number 3, state, my lords, and it is a matrimonial dispute and petitioner has to serve. They have not taken the step.
Lordship, it is served to the estate, but not to the respondent number 2, Lordship. He is deliberately, Lordship, in item number 42.
Yes.
Is respondent number 1, who is state, already served the copies, Lordship. He is appearing since from the first day, Lordship.
42, the
Point 1, my lords.
This is
Yes,
42 and 42.1.
Yes, Lordship.
Where state is not really a necessary party. What about the private respondent? You have not served.
Lordship, private respondents also served the parties. They appeared on 28th July 2025. Since then, they are not appearing, Lordship.
There was a counsel who had come, but after that, he is not.
Yes, Lordship.
Therefore, you have to effect service of notice upon him. As per the office report, service is not complete. Take steps, please. As per the office report dated 15/5/2020.
I will do it again, Lordship.
The sole respondent in TPC number 1373 of 2025 and who is respondent number 1 in diary number 18346 of 2025 still remains unserved. Necessary steps shall be taken in that regard. For the next date of hearing. List on 19th August. 43 IAs are there for withdrawal. IAs 43.
Lordship, I appear for the petition.
Do you want to transfer both cases? Or
Lordship, we are withdrawing. We are withdrawing both the transfer petitions.
Both cases. Very well.
Yes, Your Lordship.
Criminal. In the criminal MP, there's only mention of TP criminal number 57. Have you filed another IA in the other one?
The other IA lordship is the number is IA 132533 of 2026 for TP number TP number 146 of
IA numbers 134126 and 132533 of 2026 have been filed by the learned counsel for the petitioner in TP both the numbers. Mr. Tarkeshwar Nath, learned counsel appearing for the petitioner, reiterates the prayer for withdrawal of both the transfer petitions. The transfer petitions are accordingly dismissed. Stay orders in both the transfer petitions shall stand vacant. 44, there is no appearance for the state.
My lords, I appear for the petitioner, my lords. In 44, my lords, the larger question pertaining to section.
Mr. Arjit Day is also appearing for the petitioner or for the respondent?
I'm in 44.1.
Please, my lords.
You are for the petitioner?
In 44.1, my lords. R. Suresh.
But
versus State of
one is appearing for the state.
State has been served, my lords, but the wakalat has not been filed by the state in this matter yet, my lords.
Serve their designated or standing counsel, please. Despite service of notice, the state of Karnataka has not chosen to enter appearance. Learned counsel for the petitioner is permitted to effect service of notice upon the learned standing / designated counsel for the state of Karnataka.
We'll do that, my lords.
My lords, if I may, my lords. Serial number 44, my lords, the broader question is...
Whatever be the broader question, if we have issued notice...
Please, my lords.
If we have
Please, my
issued
lords.
notice, we will need to hear the state.
Please, my lords.
Let
Grateful,
the
my lords.
state come forward, thereafter we'll see.
Please, my lords.
27th August.
I'm seeking your lordship's permission to approach the High Court and withdraw the present SLP, my lords.
Sorry?
I'm seeking my lord's permission to withdraw the present SLP and approach the High Court, my lords, in view of the Sampo General judgment.
I see, very good. It's an old judgment, though.
Right, my lords.
Normally, we are not insisting on
my lords, if I may,
delegating you if it is an earlier order, because Sampo came more recently.
Yes, my lord.
And you've already spent 4 years here. But it's your choice. If you wish to go before the High Court, that's your choice.
Well, if I may assist your lordships on the last date of hearing as well, your lordships were of the opinion that since this has been filed in the year 2020 and Sampo General was in 2023, the present SLP is not unmaintainable. Subsequently, my lords, I have discovered orders of this honorable court wherein SLPs filed in the year 2021 have also been dismissed.
Yes.
And liberty has been granted.
We'll only record it as your plea for withdrawal.
Please, my lords.
Then come. What is your name, counsel?
Abhijit Singh, my lords. Abhijit Singh.
Abhijit Singh. Mr. Abhijit Singh, learned counsel representing Mr. Vishwapal Singh.
AOR.
Only Vishwapal Singh, is it not?
Yes.
Learned AOR, appearing for the petitioner, seeks permission to withdraw this special leave petition, reserving liberty to the petitioner to approach the High Court in the light of the law laid down by this court in so and so. That's Sampo General Insurance.
Please,
Permission granted, the special leave petition is accordingly dismissed with the aforestated liberty.
Grateful, your lordships.
With liberty as aforestated.
Grateful, Lord.
बताइए अगला ही है. Paso.
46.
I am seeking a short accommodation, my lords. Arguing counsel is in some personal difficulty.
Service is complete. Well, you want adjournment, is it? You're for the petitioner?
Please, my lords.
Adjournment is sought by the learned counsel for the petitioner on the ground of personal difficulty. Matter is accordingly adjourned, list on 13th August.
Much obliged.
Yes.
Please,
47.
I'm appealing for appellant, my lords.
Lords,
My lords, I'm seeking 2 weeks. My lords, I'm seeking 2 weeks time for filing of rejoinder.
Rejoinder. Counter was filed in April.
My lords, we are finalizing it.
Very good.
My lords, may kindly grant me 2 weeks.
Learned counsel for the petitioner seeks time to file a rejoinder to the counter affidavit filed by the respondent insurance company. Matters accordingly Adjourn.
I'm grateful. Lord.
List on same date. August. 48.
Much obliged, Lord.
48.
Yes, ma'am. Mr. Badiran. Yeah.
Well, it's item 48. I was praying for a Passover being led by Mr. Steve Singh.
Mr. CU Singh, is it? But R2 who's appearing, no counter has been filed by R2.
Millers, actually on the last date, we had entered appearance for the first time and sought time. There's a slight delay in receiving the final response from the corporation. If your lordships may accord us one final opportunity to then file a counter affidavit. It has not been filed.
You're appearing for R2, is
and
it?
I was not able to circulate. I'm appearing for R1 MIDC, Millers.
But on the last date, R2's counsel had asked for time.
No, Millers,
And did not file
R1.
a
It
counter
was.
till now. Yes?
Millers, I apologize. It's R2. Millers, I apologize. MIDC is R2.
MIDC, I see. You're R2 then. Very good. You need
MIDC
some more
is R2.
time then.
Please, Millers, one last opportunity may be given.
Adjournment is sought. Sorry, learned counsel for respond number 2 seeks some more time to file a counter affidavit. It should be done without fail by the next date of hearing. Rejoinder thereto, if any. Not by the next date of hearing. Give 4 weeks. Rejoinder thereto, if any, it will file within 2 weeks thereafter. Same date is.
Grateful, Millers.
49, there's a letter.
Yes, my lord, I am appearing for the petitioner, my lord.
Have you?
Letter is filed, but in the meanwhile, yesterday they have actually filed the counter. So, my lord, counter, it may not be pure your lordships.
Why?
Would my lord skip it next week so that, my lord.
But they also said that there is a change in the incumbent. I don't know what that
Yes,
means.
but
Counter is going to change.
Counter, my lord, is on record. So, my lord, I think that should be good.
Pursuant to recommendation of commission, my lord, appointment letter has already been issued.
In the first matter.
In
the first matter. Yes.
First matter, yes.
What about the other matters?
But the other matter, that's what I'm saying in contempt petition number 3 of 2026. The counter is filed yesterday. So I have received the copy. It may not be before your lordships.
They've not issued an appointment order there.
No, but they are questioning some issues, so that will have to be heard.
Oh, I see. You need to file a rejoinder to the counter.
But I will file it within 2 days. Your lordship may please have it next week.
Lord, the new incumbent may be implemented, my lord. Actually, this prayer.
I see.
Lord, he may, my learned friend may give the details. My instructing advocate will carry out the necessary.
Very good. We are informed that a counter affidavit was filed in
contempt petition number 3 of
contempt petition number 3 of 2026 yesterday. The registry may verify and put up the same. Rejoinder thereto, if any, may be filed by the next date of hearing. Details of the present incumbent shall also be furnished to enable the impleadment of the said incumbent in these contempt petitions. Based on when do you want it, Ms. Nabre?
26th, my lord, or 25th
of
25th of my lord, next week.
My lord, it will be virtual, my lord. It may be virtual, my lord. So your lordship may have it on a day when it's not virtual. My lord. That may be easier for me also.
Then 26th.
26th, the whole of that week will be miscellaneous days. You do remember that.
Yes, my lord. So,
the miscellaneous days, I'm told, will all be online.
Consider having
this is not a matter where a huge record is to be seen.
Lord, actually,
even virtual hearing will be good enough.
Might be better.
Lord, actually, my lord, I may have to show a chart, my lord. That's why I was just requesting that.
In second matter, some issues are there, my lord. So.
Very good.
Lordship in other matter.
22nd July. 22nd July.
Grateful.
Grateful.
Sorry? 50 is also here. 51. Yes.
I'm appealing for numbers 2 to 6, my lords, the Mumbai Municipal Corporation.
Yes. Counter is already filed by you. You've already filed your counter, is it not?
Yes, my lords, I have filed my counter affidavit and
appears for the petitioner. 51. No one? Pass over. Shall we pass over? Do you have any difficulty in the afternoon?
My lords, may have it on some other day. I have a difficulty because I.
Presentation for the petitioner. Learned counsel appearing for respondent numbers 2 to 6 states that he would have some difficulty in the afternoon session.
Yes.
Matter is accordingly adjourned. List on 24th August. $52 no counter.
But as I beg to appeal for the petitioner, counter is not filed.
Who appears for
They've filed
yes,
Wakalatnama.
Mr. Shubham. No counter.
Sir, I'm taking 4 weeks time to file the counter, my lord.
And counsel appearing. You are appearing for the
For
respondent.
response number 1, my lordship.
Only one, is it?
Yes, my lord.
Not the other respondent.
No, my lord.
Very well. Then counsel appearing.
But the
for
other
respondent
respondents are also instrumentalities of state.
One is a private party, though.
Yes.
Then counsel appearing for respondent number 1 seeks time to file a counter-affidavit. Usual order. Earlier order stay dated 13/3/2026 shall continue to operate to the next year. Based on September 7th.
Obliged, my lord.
53.
Lords, in item 53, I filed my objections on Saturday. Lords, I'm not sure whether it has come on record.
You filed an application with a you
Lords, I am
filed a
for the
statement of account.
Lordship, I am appearing for the respondent.
Oh,
I
you
filed
have
my
not filed
objection
it.
on.
That's what I've noted. The other
Yes,
side
so therefore-
statement of account is before us, but not yours.
Lordship, yes, I filed it on Saturday. Lords, it has not come on record probably. Lord, may I request
Who
Lordship to
appears
have it
for
next?
the applicant?
Lord, he's there online.
But this statement also, this statement is not really easy to understand because you've clubbed off all the amounts without taking into account the payments. Once a payment is made, you would have to appropriate it towards the interest due. You can't just you can't just club it date to date and quantify the.
Lord,
Is there? Anyone is there online? No one.
yes, my lord, counsel is appearing. I think he's not unmuted.
You don't see anyone also. 50.
No, I saw him there. I saw him there.
Anyhow, your statement.
Lords, my statement of objection may be allowed to come on record. Lords, may have it after some time.
Yes. Counsel for the respondent states that his statement of account was filed.
Mr. Siddharth,
yesterday.
Mr. Siddharth, speak up.
Siddharth, your statement of account is not clear. You can't just club the dates and say you need to unmute yourself. We can't hear a word you're saying.
Lord, court officer will have to unmute him.
No, sir.
Your side. The problem is at your side.
If he can hear you, just tell him what.
You'll have to give us the breakup of how you work out this account, because you have just clubbed the dates 22nd September 1998 to 19 January.
I'll file a fresh
2005
statement of
for
accounts, my lord. I don't know if I'm
calculating
audible
the
right now.
interest amount.
I've heard what's fallen from my lords. I'll supply a fresh
You'll
statement.
have to file a fresh statement of account. Learn counsel for
Just
the
tell him about the interest appropriation. Then
whatever
Lords,
payments you
Lords, for that,
receive, you will
Lords,
first
may
have
I
to
submit for that?
appropriate towards the interest.
Lord, may I submit on that? Because Lords, if Lordship will see his claim, Lords may kindly have annexure A5.
Let him file a fresh statement. We'll see your statement also. Then you can
Lordship,
tell us how you work it out.
Lordship.
Fresh statements of account shall be filed by both the applicant as well as the respondent, as we find that the applicant's statement of account dated 8/5/2006 is deficient.
Grateful, Lords.
List on Third August.
Lordship, please.
54.
May I please minutes? Minutes, it concerns the appointment of an arbitrator.
the issue falls in a narrow compass. Well, there was in 2008 a joint development agreement between me, the developer, and the respondents, the landowners. And that project had been completed. And in that process,
Little time perhaps. We'll take it up the afternoon.
As
We'll
my
take
lords
it up
indicate.
after lunch. Mr. Shankar Narayanan is opposing.
Very well, my lords, we are ready.
Yes.
After the one hearing, we will take this.
Hearings are
Sure.
One, no?
Two hearings are there. This will be the third.
Grateful.
55. Service is incomplete.
May I please, my lord, the respond numbers 8 to 18, my lord, they have.
I am applying and seeking the 4 weeks time to file the counter.
Sorry?
Seeking 4 weeks time.
My lord, respondent number
Which respondent are you appearing for?
9 to 18, they have also been served on Saturday, my lord. And the district court will upload the report.
1 to 7. 1 to 7 already shown as complete. Unserved are 9 to 18. You're saying that they are now served, is it?
On Saturday, they have been served, my lord.
You will have to file.
The court will be uploading the service report directly, my lord. They have not given to our client.
Respondent numbers 1 to 7 seeks time to file a counter-affidavit, usual order. So the office report dated 16/5/2026 reflects that the respondent numbers 9 to 18 are still unserved. Learned counsel for the petitioners states that service has been completed insofar as these respondents is concerned, and that you have to file an affidavit in proof of justice.
I will file, my lord. Otherwise,
And
they will be filing directly, my lord.
And that steps would be taken in that regard.
Should the
List
4
on
weeks time be granted?
Okay.
Please, much.
Same date, 3rd August. $56.
My lord, I appear for respondents in 56. But I request some time to file counter, my lord, and argue the matter.
In which items, Mr. Dwarkana?
56 and...
counters are filed in some matters by the looks of it.
My lord, I appear in 56.1 and 3. My lord, office report
you have to file?
No, I have not filed, my lord. Office report also shows it's not filed.
So in all those 3 cases, you need to file.
Yes, my lord. It's a common order of the High Court.
ASG, preparing for the Union of India, seeks time to file a counter-affidavit in SLPC 8611, 9257, and 9293. Is that correct?
Yes.
Of 2026. Usual order.
My lords, I appear in IA number 121279 in the same batch.
Which one?
IA number 121279.
That's an intervention application.
Yes, my lord, intervention application.
Who appears for
Gujarat
the petitioner?
Patel
I'm
versus the
appearing.
petitioner.
I'm appearing in item 56, 56.2 and 56.3, my lords. I'm the petitioner in these 3
About the
matters.
intervention applications?
No,
Some
I have no
associations want to come on record. Yes?
But
You have
I'll
no
file my
objection?
counter to that also, my lord.
How can you oppose it?
No, my lord. Because they are also asking, my lord, even though they are not concerned with the same product.
Cause, perhaps. They are espousing the same cause as Patel products.
Yes, my lords. We are in Tobacco Merchants Association, Gujarat Tobacco Merchants
That's
Association.
the reason why I have to oppose him. My lord, according to them, their product and line of...
Say that they should not be imputed when the petitioner's counsel has no objection.
No,
Petitioner's counsel is the dominus litis, is it not? Petitioner is the dominus litis. Ms. Vanita, you have no objection to the...
I have no objection, my lordships. I have no
On
objection.
record, then we'll hear them also.
Grateful, my lords.
Or the merrier, Mr. Dwaraknath.
Yes.
My lords, interim order may be continued, my lords.
Yes.
Please to
There's an
grant no
interim order.
order, no coercive steps, my lords, on the last date. The lordships may kindly continue.
We will only hear you, Mr. Mihir. We will not be granting you relief here.
Yes.
Because only Patel Products has gone through the process.
Yes.
You can't come here directly and ask for relief straight away. We will
No, my lord, there is no interim stay also that I'm asking for. There is no order against me, but I'll be affected by the order in Patel Products, and hence I wish to
To
intervene.
that extent, yes, you're entitled to be heard, but not beyond that.
Very well.
Interim order dated 12/3/2026 shall continue to operate insofar as the petitioners are concerned. Intervention applications are not opposed, hence ordered. And the interveners are brought on record as interveners and not as parties to the litigation.
Obligation.
Right.
Grateful, my lords.
Brought on record as interveners and not as parties to the litigation to enable them an opportunity of hearing and no more. '57, no counter.
We have, as on behalf of respondent number 1, I have filed my counter on Saturday, so it
It's
won't
not
be
on
before your
record.
lordships. I also have some additional documents to file, so if your lordship can put it next week, we'll be ready, my lord. That's
My lords, I beg to appear for the RP. We filed an affidavit showing the current status of the proceedings. So, my lords, post 23/3, we had invited claims. The COC stands constituted.
So you want to file a status report?
My lords, we have filed an affidavit bringing on record the current status.
You already filed it? Yes.
Yes, my lords.
Yes.
Well,
Your affidavit is-
may I make one small submission without prejudice?
Yes.
Your lordships would note that the impugned judgment was arising out of basically where I said that I would bring in, as a former director, I would bring in the money that is required to settle the matter. There's only one creditor. That's why eventually, based on a settlement, the section 12A withdrawal was permitted. After which the period of reckoning for me to bring the money in was the substantial question in the impugned judgment. I brought in 120 crores. I had 90 crores still to be left. By virtue of the stay your lordships have passed on the first day, the CIRP continues. That pretty much puts paid to any option I have of bringing that balance money of 90 crores. My only concern is if it gets pushed off for a long date, I may not be in a position to argue regarding the revival issue at all. So even while the COC stands constituted.
Why don't you deposit that money if you have it then?
Can you give me a little? The problem that I had was the land documents. The original land documents were not available with the authorities. They had to apply. Noida had to apply to get the duplicates. That is why my third party, which is Birla, with whom I entered into, they were willing to give me that money. If your lordship give me a little time, I'll try and deposit that money. If your lordship give me the liberty, I'll try and deposit it in court.
My lord, the amount has changed today, my lord. It's not the settlement amount. It is reverted back to the original amount. Can you hear me?
My lord, it's a detailed hearing had happened.
Lord, once, my lord, the settlement fails, it reverts to the original amount, not to the settlement amount.
Settlement amount is
That
how
has-
much?
The entirety of it was 210 crores, of which I paid 55, then I paid 40, and then I paid 25. Now, the date
95, also 120. Then
120 has been paid. Now, the remaining 90 was still to be paid.
Right.
But in the meanwhile, the CIRP got revived by the allowing of the application, wrongly recording that I had conceded. I had never conceded.
No, my lord,
was
I am
strong-
sorry. That my lord,
Allow
order
me
is
to
there.
complete, sir.
Yes,
Mr.
yes.
Dhawan, I'm not interrupting you. Allow me to just complete. We strongly contested it. We filed an application saying, please don't record that I have conceded. I have not conceded. That application was allowed only partly, saying instead of conceded, it used the words agreed to. I said, just give me the time. I've shown my bona fides. I've come up till here. And the clear fact is there is one creditor, only one. Now, in my view, my lords, that revival question could not arise because the
settlement,
terms
when
were
were
not
you supposed to
incorporated.
make the payment?
I'm
When
sorry,
were you
Murad?
supposed to make the payment under that settlement agreement dated 9/5/25?
There is a schedule. 55 had to be done in advance, which was done. 40 was to be done at the time of the agreement, which is 9th May 25. I did that 40. I was supposed to pay 25 further within 30 days of the commencement date. The commencement date was the date on which the NCLT allows withdrawal of the withdrawal of the insolvency proceedings. That was allowed on 31st July 25. We took the date of reckoning as the date on which that order was uploaded. The order was uploaded sometime on the 26th of August. We made the balance payment of 25 within 30 days thereafter, which is 25th September 25. So by 25th September 25, we believe that we had complied with what was required to be complied with by then. That is, within 30 days, we had finished 120 crores had been deposited.
No, but you
The
said
remaining
within
90
1 month from the date of allowing of the 12-way application.
Correct. So
the 12-way application was 31st July.
So what the date that we took, right or wrong, my lords, the date that we took was the date of the uploading of the order. That date was only 25 days later. So that
Then after the next payment after that was when?
90 days of that commencement date, 90 days. So
90
that,
days.
yes, that 90 days would take me to 26th November 2025. But well before that, on 7th of September, they filed a revival application. And I answered that revival application effectively saying you can't have a revival when the settlement has not been incorporated in the award.
What stopped you from making the payment before the NCLT allowed that application on 7th January?
The problem is that the third party with whom I had entered into, which is Birla said, we want the original documents of the land. Those original documents of the land were not with me. They were with the bank. I was trying with Noida. I was trying to get those.
You want an early date now?
I only don't want the CRP to be precipitated because I feel that I have a fairly solid argument I can take before your lordships regarding this revival.
Pay them interest for the delayed payment.
My lords, the claims that we have received as RP.
Just 1 minute, Mr. Resolution Professional. I will take instructions on that. I'm sure once we have reached 120 and we have to go to 210, a few more on that side won't be a problem. My only small submission is if there can be a status quo on the CRP.
No, I'm sorry, my lord. My lord, I'm sorry. I have something to say on this.
Stage we can't do that.
My lords,
My lord,
the
may
claims
see-
as on date are
my lord-
732 crores of the financial creditors, my lords.
No, that's with interest counting on one on top of the other.
Component, my brother has just worked it out. It's quite substantial.
Correct, my lord. Correct. That's what
45
I'm
lakhs
saying.
a month itself. At 6%, that too.
My lords, as on date,
my lord,
the claims
and my
filed
lord,
are 732 crores.
Additional
my
amount
lords.
I can take instructions on. If your lordship
No,
give me the
no.
liberty,
We'll just
I will
give you a
deposit.
short date, so let us see.
Very well.
my lord, the interim order to
Number one
continue, my
is
lord.
stated to have filed a counter-affidavit. However, the same is not on record. Registry may verify and put up the same. What anybody else needs to file
My
documents?
lord, my lord, the rejoinder has to be then filed because we have to
Rejoinder
rebut, my
thereto,
lord.
if any, may be filed by the next date of hearing.
I'm not an interim order to
Yes.
continue, my lord.
Earlier interim order dated 23/3/2026 shall continue to operate to the next hearing. Based on July 15th.
Obliged.
Take it up on.
So deeply obliged, my lords.
Obliged.
Very well. So I'm great.
So deeply obliged, my lords.
Yeah.
Yes. Item 8. No one? No one, Keshav? सुबह भी कोई नहीं था सुबह कोई पासवर्ड लिया था 8 someone had asked for a password 2 o'clock no है कोई
Mileage, I appear for the state mileage.
oh you're for the state is it
Mileage, earlier I was appearing as well, mileage. I was not muted. So, mileage, if I may just apprise, my lord,
the counsel for the
regarding the
petitioner is
status of the
missing
trial.
petitioner's counsel is missing
Oh, okay, mileage. But my lords have raised a query regarding the status of the trial, mileage. My lords, till date, no witness has been examined. However, it is at the stage. However, my lords, it is at the stage of examination of witnesses, my lords. The summons have been issued to the witnesses. They are not turning up. So, and he has one criminal antecedent.
but charge sheet was filed in September 24
Yes, yes, my lords. And the
then
charges
not
are
even
framed.
one witness has turned up
Nothing, my lords. No one has been examined. I just got a written instructions from the state, my lords. None has been examined till date.
past cases in Maharashtra
Yeah, that I have to confirm, my lords, because
that's
it
what
is
the
written.
order records perhaps
Yes, sir, my lords. That order records, the High Court's order records, my lord. Okay. It is para 4 of the Honorable High Court's order.
No, but why
Page
is the
2.
court not taking steps if the witnesses are not turning up?
My lords, that I have to see the order sheets which I have not received. This is the written instructions from the prosecutor there, my lords, which I have got.
Notice then you file a detailed affidavit.
My lords.
Your matter only. They've not, trial has not started till now. Good. Delay condoned, issue notice, turnable on. 15. So and so takes notice and waives.
Please, my lords.
18. 18.
Which one?
No one? Morning also no one was there.
May please, Your Lordships.
Yes. Yes, Mr. Noli.
Please, Your Lordships, one sec. My Lordships, in fact, that's a public, the petitioner herein is, say, the Municipal Corporation, Your Lordships. The dispute is,
921 days delay in filing.
please, Your Lordship.
It's not a criminal matter. Why should we? Plus 34 days in refiling.
No, the difficulty is it's a public road.
You're improving your case as you go along. Before the in the first appeal, you come up with some documents which don't really help you, but you say that. There's nothing in this, Mr. Nuli.
My Lordship, at best,
You want the road, you acquire the land. On the face of it, you seem to have nothing to offer. You say there's a layout, but you don't have any approval of a layout to prove.
My Lordships may at least observe that, okay, that we will acquire it and pay the.
We are not opening those. We are not even condoning the delay. We find no grounds made out to condone the inordinate delay of 921 days in the filing of the special leave petition, coupled with a further delay of 134 days in its refiling. Even on merits, we find no grounds to interfere. We condone delay petitions, and in consequence, the special leave petition are accordingly dismissed. Twenty-six. Yes, no one.
May I please, Your Lordship?
Someone asked for 26.
Am I audible to my lords? 26.
Yes.
Am I audible to my lords?
Yes, Mr.
Yes, yes, ma'am. Pursuant to filing of the special leave petition, the respondent company has been admitted into CIRP. Section 7 petition has been admitted by the NCLT Delhi. So, my lord, I would only request if this matter can just stand over for my lord, because they have now taken that in appeal before the NCLAT. So maybe that, subject to whatever may be the outcome.
Section 42, you yourself invoked Section 9 jurisdiction at Rewari.
My lord, if I
Where is the
be
question?
permitted,
Section
my lord, if I may
42
be permitted.
directly applies. Even if Delhi had jurisdiction, you yourself chose Rewari for filing your Section 9.
My lord, there is now enough sufficient case law on seat and venue. But my lord, on the maintainability aspect.
Whichever court first strike, that's it.
My lord,
Once you went before the Rewari court and invoked the Section 9 jurisdiction, that stands frozen there.
My lord, I am not. I was not addressing my lords on merit, but if my lord directs me, I shall. My lord, because for the reason now, Section 7 petition stands, like I said, admitted by the NCLT in all
So far as
proceedings.
this order is concerned, we find no grounds to interfere.
So therefore, my lord, then allow me to make my submissions on merits, please. Then, if my lord is inclined to hear the matter, I will, because there is a bar in law by virtue of Section 7. I was not addressing my lords on merit. It was my duty to inform my lords at the outset. But
dismissing this matter.
No, my lord, then kindly hear me.
The Section 7 coming in our way now.
Then kindly hear me. If that is, my lord, then kindly hear me.
This remains after 42.
My lord, 115. Section 115, my lord, there are
115, 227, that argument won't stand, Mr.
Allow me to kindly explain. Kindly. My lord, there are 3 direct judgments of this court. Sadhana loan.
Those kind of
judges of this court.
We are not going to interfere on that count.
My lord, allow me to please present it. Kindly allow me. My lord, there are 3 judges on this honorable court in Sadhana loan have clearly said there is a bar and it is not permissible to invoke jurisdiction under 227 of the, and once a remedy under 115 is available. The reason this company chose 227 was because they were in delay of in excess of 900 days. Therefore, skirting that issue, they chose to file a 227. Can I just show my lords that relevant paragraph, please? Para 15.
Even if you have a point on that, we'll say on facts, we are not inclined to interfere.
My lord, allow me to present it, please. Allow me. My lord, I have a very good case. My lord,
you sealed your fate by filing the Section 9 before the district judge at Rewari.
My lord, I have a reply to that. And let me say this. My lord, Section 9 was also filed in Delhi.
My judgment as a High Court judge is against you on this count. So I can't take a different view now.
My lord, I have not had the occasion to look at that judgment. Kindly allow me to look at that judgment. And I will be able to maybe make an effort to satisfy my lord. Maybe, my lord, facts of that case may be different.
To interfere with
my lord, kindly hear me.
By the High Court, the specially
My lord, please hear me. My lord,
we are not going to interfere with this.
My lord, kindly hear me. I'm just seeking my lord's indulgence to hear me. After that, whatever view my lord will take, I bow down to it. My lord, just kindly hear me. My lord, I think a litigant has...
227, 115, all right, we agree with you, but on facts, we are not inclined to apply.
Okay, my lord, if satisfied on that aspect, then second aspect, can I address my lord on the second aspect, please?
What is the second aspect?
My lord, on the aspect of whether on 42, my lord, there is a parallel Section 9 was filed in Delhi. Also, second, 50 sittings of the learned sole arbitrator, the former Chief Justice of India, took place at Delhi. The stamp paper was bought Delhi.
When was the Delhi Section 9 filed?
My lord, I will just give the date, please.
Earlier one was at Rewari.
Yes, my lord, there are 2 Section 9s filed. And my lord, then...
Where do you get the details of this?
Sorry?
Where do you get the details of these 2 sections? Both filed by you, is it?
Yes, my lord. Both were filed by me.
Why 2 separate courts?
My lord, because the second time when I went to the Chandigarh High Court, Section 11, my lord, for seeking an extension, my lord, the Honorable High Court did not permit me and said the relevant court would be Delhi. So I was relegated to Delhi High Court, where I filed Section 29A.
You've been going back and forth.
My lord, I was no. The High Court sent me away. The Punjab and Haryana High Court said we will not entertain 29A, and you go to Delhi High Court. They sent me.
A invocation is also before the Punjab and Haryana High Court.
Sorry?
The 29A invocation is also there.
No. 29A, there are 4 applications before Delhi High Court. There are 4 applications before Delhi High Court.
First one is the Section 9 that you filed on 14th May 2015 before the District Judge at Rewari.
My lord has paragraph 5. My lord has paragraph 5 of the order.
The first one is on 14th May.
I'm pointing out, requesting my lord to read paragraph 5, please.
Paragraph 5. Yes.
Thereafter, response filed another application under Section 29A before Delhi High Court, which was the 3rd application filed by them.
Later, much later. Before
Yes.
that,
Before that, please have paragraph 4.
15.
Yes.
14th May 2015, you went before the District Judge.
So, my lord, just the prior page and right at the top, page 4, first line, an application under 29A of the Act before this court and wide order dated 29/9/17, an extension was granted by the coordinate bench of this court on the basis of the consent of both the parties. Thereafter, the arbitral proceedings could not be concluded within the aforesaid extended period of time, and another application for further extension was filed before this court, which was withdrawn, wide order dated so and so, with liberty to take appropriate remedy as available in law. Both the aforesaid orders, that is P8 and P9, are reproduced hereunder. 5. Thereafter, respondents filed another application 29A before the Delhi High Court, which is the 3rd application filed by them, which is P10, and the same was allowed, and the time was for concluding the arbitral proceedings was
This is
extended.
all much later, Mr. Yadav.
My lord, so therefore, I have demonstrated that these are running in parallel. They have run in parallel.
Entertainment of these parallel proceedings itself was wrong, because once the first Section 9 was in the jurisdiction of Punjab and Haryana High Court, there ends the matter.
My lord, may I just point out one last fact, my lord? If I'm not being able to persuade my lord on 115 and on this aspect, may I just place this, my lord? Lastly, my lord, in BGS SOMA, my lord, it has been said wherever the seat is not defined and the venue is defined, that is the court which will have the jurisdictional right.
Therefore, accepting that, if you had a choice of 2 and you made your option by filing your Section 9, the first Section 9 on 14th May 2015, your fate stood settled there. That's all there is to it. All facts we find no good ground and reason to interfere with the impugned judgment passed by the High Court, especially petitions accordingly dismissed.
My lord, may I seek the liberty to withdraw it then, my lord?
No, we do not permit withdrawals, Mr. Yadav.
Very well. Thank you. Very kind of my lords to have heard me. Thank you.
28. 28.
Am I audible, Malaz?
Yes.
Malaz, award, the question framed is at page 127, Malaz.
One moment.
Please, Malaz.
Yes. Yes, Mr. Balbi.
Please, Malaz. Malaz, the question framed by the tribunal is at 127. For a minute, my lords can kindly see.
Yes.
First question in para 22, Malaz. Whether the claimant retired from partnership deed after receiving 1,65,000 from the respondent. This was the question frame or the issue number 1. On page 129, after examining everything and particularly 2-3 paras on 129, middle of the page, from perusal of this retirement deed, that's how it starts in finding, Malas, on maybe 8th-10th line from the top. From perusal of this retirement deed, that's how it starts.
Page 129.
Yes, Malas. This is the finding on first issue. From perusal of this retirement deed, it is clear that... I'm sorry, Malas have got it, Malas?
Page 129 on perusal. I don't find it there.
Malas, it's 8th or 9th line, middle of the line, from perusal of this retirement deed.
Oh, from perusal. All right. I
Yes.
was looking for on perusal. Very well.
Oh, I'm sorry, Malas, I'm sorry.
From perusal.
From perusal of this retirement deed, it is clear that nothing was paid by respondent number 2 to claimant. Though claim of respondent number 2 is that rupees 1,65,000 were paid to the respondent number 4 and the claimant, it is the case of the respondent number 2 in his cross-examination, which will be decided later on in detail, that the accounts were settled by the claimant. It is admission of respondent number 2 in retirement deed that all the records shall be with the respondent number 2 and other respondent. If the account was settled, it should have been placed on record, which respondent number 2 failed to do so. Very material facts have not been mentioned in the retirement deed, etc. That the amount of 1,60,000 was paid. My claim was that the retirement deed, which was not acted upon because I was never paid this amount. Based on this, I succeeded the tribunal to say that I have not retired from the partnership. 34 court, Malas, frames a question which is completely
Retirement
different.
deed is signed by you.
Yes, it is. I'm agreeing.
Wait, 1235.
1235, Malas.
155.
155. Yes.
Para 41.
Apart from, just see it from apart from.
Rather, if we see 154 for a minute also, Malas. 154, para 37, it is by 34 court.
Please, Mr. Balbir Singh, wait a minute.
Sorry, Malas, sorry.
Then
Page 155 and 156, where you
Malas,
admit your signatures on the retirement deed.
Yes, Malas, this was always my case. My case was never...
Your
Kindly see-
claim was that you had signed on some blank stamp papers.
That is the
On
subsequent...
the face of it was not believable at all because given the
Yes.
atmosphere
I'm not-
there, you would hardly have signed on blank signed papers when your mother.
I'm not... My
was
case is
having an
not...
issue there.
Well, kindly see the question framed by the now High Court, para 37, page 154. My case was never that the deed was not signed. My case was that deed was not acted upon. 1,65,000 was not dispersed to the partners who are retiring. As a result, the partnership sustained. What 34 court frames is para 37, Malas.
Yes.
Thus, the principal question to be addressed by the arbitral tribunal was whether the BK, had signed any blank papers which had been subsequently misused to reflect his retirement. This is not the question. I never claimed that. This was in
his
context
claim is for the money.
What was your claim for then? Let us show it.
Yes.
Let us
Yes,
see your
Malas.
claim.
That's the reason my claim
Let
was...
us see your claim statement. What exactly did you say?
Malas, I can read from the award, if my lords kindly
Not
allow
file
me
a
to...
copy of the claim statement. Very well. Let
Malas,
us
I
see
can
from
file-
the award itself.
Malas, if we can come to...
Award also is not there.
Well, the award is there. That's the
So
question.
if it has been filed.
One page.
Part of it deals with your claim. Let us see.
Yes, page 125, para 17, Malas, and 17 onwards is what I have said. And probably the confusion which created was the form 5. My case is not a form 5.
But your claim seems to have been that you are continuing as a partner there.
Yes, that's what
On
I'm
one
saying.
hand, you say that I never signed a retirement deed. I signed on blank paper.
See 116 and 117.
Kindly see one page 125, para 17.
One 116 and 117. This is what you said. Never discussed with him about the retirement from the firm.
Yes, so just to clarify what the confusion is created about the unsigned.
According to claimant's firm. Not
Para 17 on page 125.
So you could have only asked, sued for the amount which was due to you under the retirement deed. There's no question of you're taking these kind of contradictory pleas that I never signed a retirement deed. I signed on blank stamp papers.
I signed.
And then saying that no, this amount is due to me.
No, this was never a case because this partnership we are existing is the second generation partnership. The parents of the partners were partners. I'm partners for generations in this. What was decided was that if you want to page.
We are not inclined to interfere with this.
Well, page 125, kindly see
only the 34 court and 37 court held against.
The wrong question framed. Absolutely. I'm making a statement. My claim is not that the deed was unsigned. Deed was signed. It was a form 5 which was the unsigned, Malasi.
Balloons जो जा रहे थे अभी वो उनके तरफ से होता है या अपने तरफ से होता है?
Malasi, it depends on who punched that because there is one icon which
you seem to have done it, Mr. Balbir. So I was wondering why you're sending up balloons when we are about to dismiss your case.
Well, I have not touched that. So possibly my lords are using something which the balloon, and I have not seen it was visible to my lords. So possibly the screen working in my favor, I would say. First to clarify.
There's nothing here to interfere with.
I'm first of all, the question which has been framed by 34 court, I'm admitting right from the day one. It was this document of deed which was signed by me.
Oh, you were not very clear as to what you went before the arbitrator with. Deny your statement, then you say my amount is due under the same document.
No,
so the arbitrator is also left clueless as to where he should go.
But the award is very clear.
That award was doomed from the word go because of your lack of consistency.
But the award is in my favor. So let's make it clear. The award is my favor.
The award is in your favor, no doubt. The 34 and 37 both held against you.
My finding will come from page 125. Only two paras. That will make it clear. Page 125.
Yes.
Para 17.
Yes.
According to claimant, he is still legal partner of the respondent number 1 and entitled to all assets and property of the respondent number 1 as per the shares in partnership deeds. 18. Now this is important, Malas. Defense put up by respondent number 2 in his affidavit in evidence as well as in reply to claim petition is that the claimant, having retired from the respondent number 1, has no concern with the assets owned by it. According to respondent number 2, at the time of retirement, account of the firm was settled and amount due payable to the outgoing partner were paid. According to respondent number 2, claimant and respondent number 4 were each paid a sum of rupees 1,65,000 on retirement. The retirement deed was drawn on 19/1, which was duly signed by the claimant and respondent number 4 on 19/1/2020. My case was this deed which was signed by two partners, they never retired because this amount was not dispersed. The accounts were thereafter maintained continuously.
Once you signed it, if the amounts were not returned to you, then you file a suit for recovery of money.
Because subsequently accounts are maintained based on a partnership deed share. I still hold 33% share in that partnership.
However, we find no good ground and reason to interfere with the impugned judgment passed by the High Court, especially petitions accordingly.
Very well.
58.
May I please, Lord? Well, this was a contempt petition similar to what my lord had decided on the Telangana matter.
Who appears for the respondents?
Office report service is complete by all modes.
My lords, if you've just filed a wakalatnama today, I'm awaiting instructions. I'll file my affidavit in a course of 2 weeks, my lords.
I'm slightly opposing that.
Which we have referred to. We have referred to a judgment in the notice order.
Indeed, my lord.
My lords.
That would squarely apply to you, so you can advise your clients accordingly.
My lords, I will. My lords, 2 weeks we'll file a compliance most likely.
And Council appearing for the respondents. takes time. Yes,
But
yes.
yes, I just want to make one request, my lord. Post the summer vacation, the next academic session will start. So all that I'm requesting is this, my lord, because the order originally was of October 25, had to be complied by January. Of course, review petition, etc. I won't take my lords again through that because in the Telangana matter, my lords have seen. Can I just request, my lord, that kindly give me a date this side of vacation so that they can report compliance? Because if it comes after vacation and we do compliance after summer break, I will lose
Give
one
the
academic.
council only a week's time then.
My
Then
lords
can
may
you
have
do
it on Friday, my lords, the last day of vacation.
That's a
I'll
very
file
fair
my
submission to
application.
make.
Yes,
I'm grateful for my learned friend. Lord, and one
29.
query, my lord, I put that those balloons come because of the victory sign. Whenever there'll be a victory sign on Apple, my lord,
I
by
see.
anyone, so the balloons will come. My lord had put in the last matter, why were the balloons coming?
I did not make a victory sign and Mr. Balbir was not entitled because we
So,
were
Lord, whenever in Apple there'll be a thumbs up or there'll be a victory sign, then balloons will come. That is the absolute
Why
problem.
is it not happening now then? You did both.
Because I have turned it off. So that there's no distraction.
Well, Mr. Balbir, you must have done it there.
Yeah, possibly. So grateful, Lords. Lords will have it on the last day of
Yes,
vacation.
29.
I'm so grateful, Lords. Deeply grateful.
59. You are for?
My lords, I'm an intervener in item number 59.
These applications now, to begin with, other concessions in para 49 would have application only to disabled candidates. The sentence does not lend itself to the interpretation that other concessions should be extended to all untainted candidates. That's not how the sentence.
Lord, I'm appearing in 59. That is a contempt petition.
Many applications were moved, Lord. Lordship was kind of dismiss all. They're trying to create trouble by making these applications.
That is my submission also. I am in 59.1. This is a complete.
59.1, I'm for the petitioners. Lord, 59.1, may I submit, Lord, with great respect. Lord, this is one selection where all the well-accepted norms of recruitment have been transgressed.
We are not arguing the main case here.
All over now. Case is already over.
We are not arguing the main case. Question is whether there is.
All these points were argued. 185 applications were dismissed.
But in the contempt matter, I'm appearing in the contempt matter. I'm not
there, you're not there.
Malas, I am representing a teacher, Malas. He's 75% blind, Malas. He's 57 years old, Malas. Therefore, Malas, we wanted Malas clarification on the questions, Malas.
Listed me.
75% blind, Malas, and Malas 57-year-old.
Petitions are pending.
The petition sent.
I'm not.
All these points were argued
on the clarification, Malas.
Lord, may I submit with great respect?
We find no grounds to entertain these applications filed for clarification. What are they called? Clarification of the judgment dated.
Malas, may then allow me to withdraw the application for clarification, Malas.
4800
I'm not
2025 and
persons
back.
who are asking for clarifications.
My lords,
Not for them. I'm against them. Because they have listed me in a list.
First of all, there is a contempt petition.
Candidate, my lords. I'm not.
Contempt petition first.
There's no question of our going into it because that issue was never before us.
Go down to that, my lords.
If you had raised the only one candidate who did have a case in that
my lords,
yes,
very well, my lords.
in that issue, on that issue was a person who had filed a writ petition even before the closure of the case by the Calcutta High Court itself. That was the only case we said her case alone requires to be examined because we never went into the issue as to who is tainted, who is not tainted.
Exactly, my lords.
So if you have a cause in that regard, you ought to have raised it prior to this happening.
My lords.
Because before us, everyone was certain as to whether they were tainted or not tainted.
Totally agree with
Because they all
that is why, Lord, we are in
the
contempt petition.
candidates. Now you can't say that there was a doubt and we want to reopen that issue now. Sorry.
Absolutely right, Lord.
Well, as a matter of routine, these applications
The
are
final process is over, your lordships, no more
Malas, the
applications.
issue is,
come.
Malas, they have
Not in
Delays
one
the process
59
all
point.
the time.
Lord, can I just
Nothing.
speak?
Malas, the second issue is, Malas, the number of
At the same time, I can't
candidates for a
make a
particular category that has
So
been, Malas,
we'll go
altered by
with
the
ladies
Malas,
first. So Ms.
department,
Makija,
Malas.
yes.
Lord, 59.1 is the contempt petition.
Are you a lady? Mr.
Lord,
Masoodi?
59. I am
not a lady. I said ladies first. Miss Makija goes.
all right, all right.
Yes, Your Lordships. Your Lordships, all that I'm praying for is that these applications and contempt petitions are repeatedly coming through different people, but on the same grounds. If Your Lordships may kindly, till the time that West Bengal Service Board finishes the no application should come, Your Lordships. They are all on the same grounds. On a previous occasion,
all the filing of applications.
Your Lordships may then observe that the recruitment must go on, Your Lordships.
We have not stated. Where's the question of it not going on?
There is no stay.
It is going on. The recruitment is going on. We can't stall the filing of cases. That's not right. Yes,
Yes, Your Lordships may kindly say that the recruitment be completed
these
as
are all
per
frivolous
stated by Your
applications.
Lordships earlier. By 31st August.
Stop the filing of
Lordships
it.
have given that deadline.
Let's see what.
Link has been sent to 800 people, my lords, who are listed wrongly in this clarification application, my lords. They have not listed an order that is dated 7th of 7/7/2023.
The later one.
Yes, my lord.
Allowing the untainted candidates.
This list of 5757 people, my lords, where 2-3 recommendation letters are there. They have not attached the Gazette notification of 2016, my lords, and they are coming from.
Anyhow, we are not entertaining anything. Yes, Mr.
Madam, if I just may.
Lord, may I, with great respect, Lord, the transgression and the rampant illegalities which were noticed by the Honorable Supreme Court, Lord, I invite my Lord's kind attention to page 77 directly. It's a small paragraph, Lord. May I be permitted to read it out?
Sorry?
The claim that the data on the 3 hard disks shows no interpolation and is consistent with the data in Messrs. Data so-and-so solutions computers fails to account for significant gaps and discrepancies. These issues highlighted in both the impugned judgment and our findings clearly point out to large-scale manipulation and tampering with results, including rank jumping, discrepancies in marks, the issuance of appointment letters to candidates not on the panel.
What do you want from that now?
Now, my Lord, this is what has been noticed and what finally the Honorable Supreme Court, my Lord, approved and affirmed the judgment rendered by the High Court. Now, our grievance is, my Lord, I have taken up the matter in 2 parts. Now, these 4 categories, in paragraph 28, if your Lordship may have at page 28, what I say is that the Honorable Supreme Court, with respect to the appointments, when it applied mine, it found that 6,276 candidates who were tainted were appointed and their appointments were quashed.
We never mentioned any numbers, but anyhow.
Yes, your Lordship may kindly have the numbers are there in paragraph 26 of the.
If I can make a preliminary submission, these very people had first filed one IA before the registrar. The registrar refused to entertain it. They withdrew it.
Because there is a question which has
just 1 minute.
as to the figures.
Just 1 minute. They have filed a second IA before your Lordships and sought permission to withdraw it. And now this contempt, it's a misuse of the process.
No, it's not. It is simply we are not going for the multiplicity of proceedings which have ultimately been settled by the apex court in great clarity. No, my Lord, the figures your Lordships were pleased to ask me. Please kindly have not page 70. Page 70, your Lordship may kindly have at the bottom, the figures are disclosed by the apex court in its judgment. Lord, last paragraph, Lord, in the last part of of this page 70, Lord, the apex court says, records that the commission claimed that 57 Group C and 107 Group D selectees, appointees with OMR mismatch were not recommended or appointed. However, their names also figure in the list.
Where are you reading?
Appointed through rank jumping and out of panel.
Where are you reading, Counsel?
Page 70, Lord.
Page 70 of 59.1.
This is paragraph 26 of the apex court judgment and page 70 at the bottom, Lord.
Yes.
Where WBSSC claims. This is the commission, Lord.
Yes.
Now, my lord, in this paragraph, the last sentence begins, the commission admits that
Claims that 57 group.
1,058.
Then
An admission is not.
Now, this is an admission of the commission.
acknowledges. We have not said anything.
Now,
WBSSC
next page. Lord, on page
acknowledges
71.
that so and so illegal appointments were made.
On page
We have
71.
never gone into the numbers or decided who's tainted, who's not tainted.
Kindly have page 71. Kindly have page 71. Please turn this page, my lord, then your lordship may have. Thus, excluding 239 candidates who fall under both OMR mismatch and other illegalities, Commission acknowledges that 6,276 illegal appointments were made.
That's the commission's acknowledgement.
Out of this 6,276, what they have done is what I have stated in paragraph 26 and page 28. Out of these 6,276, they have notified the illegal appointments, confining them, tainted candidates, confining them to 5,318. And 958 candidates are nevertheless.
We have already said that all issues will be raised before the High Court. So where there's no question of again coming back.
They have raised it, the writ has already been dismissed. They raised this petition, they filed a writ, writ is dismissed. They came in SLP, SLP dismissed. Now dismissed.
All the contempt
Dismiss this
My
application.
lords, if I just,
judgment.
my lords, if I just,
2025.
One last submission of clarification.
Two contempt petitions, Lord, regarding the same judgment.
2025 and batch.
Notice
The
was
applications
issued.
as well as the contempt petitions are accordingly dismissed.
The original contempt is pending.
My lords, if I just may,
Why this contempt
The
again?
contempt petition is pending before this court.
That is for a totally different issue. It has nothing to do with this.
No.
These contempt petitions, they are dismissing. They're in.
my lords, if I just may mention item 59.3 I pair for the applicants in that matter. We circulated a withdrawal letter on Friday. That is on.
What exactly is that?
16th
Is
of
it an application or a contempt?
Same application, your lordship.
It's an application, the same as
Seeking
contempt.
clarification, my lord. We wish to withdraw. We circulated a letter on
It's
Friday.
an intervention application. In that clarification application, my lords.
You filed an intervention.
Yes, my lords. And that.
So now they've given up to want to withdraw.
My lords, with due respect, I would just submit that we've not gone into the merits of the case. Therefore, they have no locus.
We are not going to give you any liberties.
Yes.
Be certain about that.
Your lordship may kindly bear with me for a second. The same contempt matter on one facet of the
This
of the
main
same
application
judgment,
with
Lord.
MA. This is the IA in. This is the very good. MA number 26462 of 2026, Mr. Varun Rawat, Learned Counsel, representing Mr. Jain Nami. This Mr. Jain Namisha Anuj. Man or woman?
Woman,
Namisha
sir.
Anuj Jain, my lords. Namisha Anuj.
Oh, it's Miss Namisha Anuj.
Miss
Jain.
Namisha.
Miss Namisha Anuj Jain seeks permission to withdraw the application filed for clarification. The application is permission granted. The application is accordingly dismissed as withdrawn.
Very grateful, your lordship.
Lord, the last submission,
Grateful.
your lordship may kindly have page 401. Just
Your
correct.
matter is already over, Mr. Muslim.
Just one second, my lord, if your lordship.
I deeply obliged, Lord. The application
Minutes indulgence, if your
Very
lordship may
grateful,
kindly
Lord.
grant.
Grateful to your lordship.
Over now.
Grateful.
That's all. Item 60.
Please allow us to appear physically, my lord.
Yes, Mr. Good. How did you get here?
But we were in chambers.
How did you get to the chamber?
It is not prohibited. Even your lordship's doors are open. Since we were in chambers, some other counsels were appearing. My friend has come from Bangalore. He thought that we should go there.
Everybody is driving to the chambers within the Supreme Court, but you're not coming inside and arguing, is it? What is the logic? I thought the entire logic was nobody would come to the Supreme Court at all. But all of you have your offices here.
Full of cars.
Oh, what the point is. Anyhow, so you are here. All right.
We are grateful.
Yes,
My
Ms.
friend
Gupta.
Bangalore, he wanted to, my lords, come physically, so we have.
Yes.
Now, my lords, please have page 227. Lords, I have an eviction decree against me. The
But
mean
this
profits-
affidavit that you file, you try to be a little too smart for your own good.
I'm not.
If the High Court says file an affidavit saying that you're going to vacate these 16 rooms, you can just say pursuant to that order, I'm vacating. Why do you have to say this is only because out of respect for the order of the High Court, this does not foreclose my rights? Your appeal is pending anyhow.
Clarify.
So why do you say all these things?
Is right, but I want to clarify. If after this chronology, if your lordship feels that we have to change our affidavit, we will.
Look at your affidavit once, 238.
Can I show 2 to 7 once? Permit me. Lord.
2
What
to
did the Honorable
7.
High Court 2 to 7? That's 18th December 25 order against which my SLP is dismissed. So I want to show this order, Lord. Now, in a first appeal, I am asked to file an affidavit to vacate before adjudicating the appeal. But that's all right, Lord. Please see the last 4 lines. The admitted rent shall be paid on or before 5th of every month. This order is without prejudice to the contentions of the parties. The appellant shall place on record the affidavit in terms of this order within 3 weeks from today. The affidavit had to be without prejudice, my lord. My first appeal is pending before the Honorable High Court. Now, my lord, I come to your lordship. Your lordship.
The order already records it. Why do you have to say it in your affidavit again?
Something else. Now, I'm saying something else, my lord.
This order records that whatever you do is going to be without prejudice to the contentions.
So the prejudice I will show. Just give me one more second. My lord, in all fairness, your lordship dismissed our SLP against this order at page 235. Because we were wanting to say that, my lord, the appeal cannot be prejudged during pendency of my eviction.
You're a sublessee. You're a sublessee. And your lessee's lease is over.
No, not yet.
That is over 26 June. End of
But
June.
he has not said that Papanna has, my lord, instituted any suit against him, who is his lessor. So, my lord, now please see, after your lordship dismissed my SLP at page 235, I have filed the affidavit, my lord, at page 238. I
Look
was
at
not
your
there.
affidavit, please.
Yes, my lord. Affidavit.
Not once, but again and again.
What does a party do? My lords, I am in an eviction.
Why
appeal.
do you have to do that? Anyhow, you are abiding by the order. Otherwise, the delivery warrant is already issued in the execution petition.
In my favor since the time
So you
I filed
want
the
the
appeal.
stay is conditional, then you have to abide by the condition. You can't again bargain over the condition and say that I'll file an affidavit, but I'll do it on my own terms.
Problem today. Lords, please appreciate our problem.
Extend.
Lords, please, I'm sorry. Please appreciate the concern of a litigant. He is in an eviction appeal. He said that before deciding your appeal, you have to file an affidavit to vacate. Now, my lords, even that I have filed, but without
Now, what
this
happened
minor-
on the next day? 3 days time was given. That was long ago.
I have filed the affidavit. Now, please see the impugned order. I want to show my concern, Lord. What is
What
the-
impugned
please have
order?
Page 2. Page 2, my lord, is the impugned
Page
order.
2 is the 22nd April order, which gave you 3 days time to file a better affidavit. You've not filed it.
Lord, I want to show one thing. Lord.
No, did you file it pursuant to this?
Fresh affidavit because we have come to your lordships immediately. But please have my concern. Now that I have told all of this to your lordship, please have my concern. What does the Honorable High Court do? Lord, please have para 2 of this order. The affidavit by way of undertaking filed by appellant dated 25/2 is not in compliance with the directions of this court. Not the Honorable High Court also said without prejudice. Therefore, I added without prejudice. Let a fresh affidavit fill. Now, please see para 4. List on 13 July 26. And I am asked to vacate by 30th of June 26. Lord.
You have to vacate.
No, but Lord, my appeal having not
You
been...
can always go back into the premises again if you win.
This is not possible. Now, Lord,
You're
my
running
request is twofold.
You're running a hotel anyway.
Restore your possession.
Sorry, my lord.
You think the High Court will not be able to restore your possession?
I'm not saying that.
You're running a hotel anyway. It's not like it's a...
But Lord, 48 rooms I already have out of those 16. Now, Lord, in all my humble submission, this is unheard of. Your lordship will never pass this order that in an eviction appeal, if your
Once
lordship...
the High Court imposes a condition, you are expected to abide by that order. All that you had to say was in terms of the order dated so and so, I'm filing the affidavit. End of the matter.
Lord, I
You want to be smart about it and say all these things, then obviously you are rubbing the High Court the wrong way.
This background I have given not for notice. I just want one single
Nothing more,
sentence.
Mr.
Lord, our concern, lordship may hear and then lordship dismiss. The concern is this. Lords, I will file a better affidavit. I will file an unconditional affidavit. Lords, the Honorable High Court is reopening on 1st of June. Since I have been asked to vacate on 30th of June, there are 30 days, Lords. Let my appeal be decided at least in the first week of June.
We are not going.
Lords, otherwise, Lord, this puts the cart
We
before
are
the
not
horse.
going to fix a time.
Where does the litigant go? Lords, I am just wanting to say
You
this.
want a stay, is it not? Otherwise, the
Don't
execution
give us
can
a
go
stay.
on.
I have a stay. Till 30th of June, High Court has not asked me to vacate.
Can
But
be restored into possession.
Lords, but in an eviction suit, after having given
Find
me
no
a
good
stay,
ground and reason to interfere with the impugned interim order passed by the High Court. Especially if petition is accordingly dismissed. The petitioner shall file an affidavit as directed by the High Court within 3 days from today.
you will do that. And Lord, then Lordship may at least.
Nothing more.
No, before 30th of June, Lord.
We are giving you 3 more days. Be happy about that.
Equities have to be balanced, Lord. And
That is the equity. You get 3 more days time, though you did not file it within that time. 25. Okay, file
I
it.
get a stay on deposit of 75%. I deposit that, Lord.
Nothing more, Mr. Gagan.
Now, without a modification application, this stay order is modified to say that you file an undertaking before my appeal getting adjudicated. Lord, this in my
File it, please.
Lord, this is
Nothing more. Nothing more at this stage.
No, Lord, nothing.
Nothing more at this stage.
For a tenant to come back, Lord, in the premises, Lord, is.
You're a sublessee whose lessor's lease is running out. Where's the question?
30 years and I'm running a hotel. These are meant to be long-term leases.
Very good.
Now, Lord,
Nothing
I have
more.
my remedy until this honorable court.
This
I can't
lease
shut
deed
down.
is of 12th January 1990.
I'm only
Then,
saying that.
where's the question?
Does that bar my appeal or an SLP? I am only saying that decide my
At some point of time, you need to give back the property to a landlord.
But subject to the
You don't develop roots because you are a tenant there.
I'll tell you, Lord,
But unfortunately, here, all tenants seem to think that they can develop roots.
the problem here is this. One small
Some
problem.
point of time, the owner is entitled to get his property back.
So therefore, Lord, one small problem here on merits is this, which is why we were pressing that appeal should get decided on merits.
Nothing more. We are not going to fix a time frame. Be certain.
2 more minutes.
Nothing more, Mr. Gagan.
One problem I want to tell the High Court is that only 4 out of 9 landlords have come, Lord, under 108Q. I must give.
Raise all those issues there. We are not going to go into all.
But I must give back.
We are on a limited count here. That's all. Over now.
But at least
Next.
a request to the High Court lordships can make.
Next matter. Nothing more.
Request to decide 30th.
Nothing more, Mr. Gagan.
Please, Lordship. Lordships in TT Anthony said there can't be a
All
second
your
FIR.
FIRs are in District Ahmedabad City. All your FIR.
Just see, in first principal FIR,
Be bothered within the same district to get bail orders, is it?
Lordship, just see, in first principal FIR, I have been granted bail saying that arrest is illegal, violation of 21-22.
Well, these kind of prayers.
When before I come out, second FIR got lodged.
Criminal law justice system is not there to serve the accused. Most of the accused seem to be under that impression. No coercive steps, not to do register FIRs, no arrest, no custodial interrogation.
No, principal FIR,
after
I
all
have been granted bail saying that my arrest is illegal, detention is illegal, violation of Article 21-22. Immediately, second FIR lodged, I was taken over in that.
This many people for a ride, each of them is entitled to register a FIR, is it not?
Lordship Justice. Lordship in Amish Devgan and
nothing more.
Kodela said
You find